I'm appearing on behalf of the GA applicant. This is my application.
GA, which application?
GA 109 of 2014. Lordship, this particular record is missing and is not traceable. For this reason, Lordship, I'm humbly praying for the reconstruction of this particular application.
There was a direction.
There was a direction.
Huh? Oh, in this case, there is no records.
I've mentioned several times.
Okay. So this
Reconstruction is necessary, Lordship, as the record is not traceable. The department cannot find it.
Yes. Kono report এসছে কি যে record is not traceable? Yes, record and order. Learned advocate for the
applicant. Intervener
and learned receiver advocate for the receiver is present. As the records of this case is not put up, let the records be put up on the next date fixed. Register original site is requested to look into this matter so that the records are put up on the next date. Let this matter appear on 24/9/2025.
Lordship, kindly pass the direction for the reconstruction of.
No, let me see the report that whether the records are not traceable. It is only this if they say that the records are not traceable, that order can be passed.
Okay, Lordship.
Yes, 24/9.
Deeply grateful. 24/9.
My lord, I am appealing for the plaintiff number 1. And yesterday, I have gone through the report, my lord. What happened in this matter? This paragraph has to be inserted because the purchase was done. 2N, I have made that.
No. Which case? That is item?
Item number 5, my lord.
Item number 5. The record is not here. Records. Today is fixed for the report.
Yes, my lord. Lordship asked me to go through the report of the register.
Yes.
I have gone through, my lord.
No, there was a direction, 21st August 2025.
Yes.
So there was a direction so that the amendments are carried out.
Yes, my lord. What
Okay, now let me see. Yes, have you gone through this report?
Yes. What happened, my lord? The amendment that if plaintiff number 2A2 has purchased, his name should be added to this plaintiff. By which order he has got this share, that has been narrated in 2N. That's why they could not tally, because the incident took place in 2024. The suit is of 9, and 2N has been stated in 2O. I am praying leave to underline 2N2O.
Paragraph number 2 and 2O.
4 and 5. 6 has already been underlined.
So this should be a proposed amendment.
Yes, my lord. It is.
So that way, that is not a, that prayer was not there.
Yes, my lord.
Yes, record and order.
Leave be granted to
Learned advocate for the plaintiff is present. Here is the report of the registrar dated 8 September 2025. It appears that by order dated 21st August 2025, the petition for amendment was allowed. Stopped. However, it appears in the report that paragraph number 2 capital N annexed with the petition GA 21 of 2025 marked as annexure B is not tallying with paragraph number 2 capital N of the original plaint. It is further stated that paragraph number 2 capital O, 4 and 5 of the proposed amended plaint marked as annexure B are not present in the original plaint. Stop. Learned advocate for the plaintiff prays for leave to underline the paragraph marked as 2 capital N, 2 capital O, 4 and 5 of the proposed amended plaint. Such prayer is allowed. The order dated 21st August 2025 is modified to that extent. Other contents of the order dated 21st August 2025 remain unaltered.
Department to act.
Yes,
Department
yes, department to take necessary steps on this order. Modification হলো just.
Lord, item number 6, I tell you, Lordship, Lord, in this matter, I was appointed a receiver, and Lordship, Lord, understood my difficulty, discharged me, and I have handed over all documents to the learned registrar, and I have a copy of that.
Appear for the one of the added defendants, my lord. I had some.
One thing, Lord, I tell you, Lordship, Lordship sees the report.
Yes, so necessary rectification and modification is already done.
Well done, and this is the copy, my lord, I have received from the learned registrar. After I handed over, he acknowledged the same. And Lordship, my lord, also directed me to serve the copy of that order whereby I was discharged upon all parties.
Yes, yes.
I served. Now,
You are appearing for?
One of the added defendant.
one difficulty is there. The plaintiffs, their entire punch, my lord, came back. I have the copy. Some of the defendants, my lord, they were not there, returned. Probably only one defendant had received, and I have discharged my duty. Now, today, what had happened, I served, my lord, at the address mentioned in the cause title to the parties whose names are there in the plaint, because what had happened after 15 years before, I honestly cannot recollect. Now, today, my learned friend came and he said his client's name was added. So I did not.
Anyway, the
recollect.
appearance can be recorded at
No,
best.
I have served him also today. I didn't want to go into this controversy. Kindly record that I have served the letter which
Terms of that order dated 29th August.
I have served him also. Record his presence, because his name or his client's name probably is not appearing in the cause title.
Well,
I don't think it has been amended.
I was added as a party by virtue of an order dated 20th of March 2015.
Anyway, now you are aware
Now I'm aware, my lord. I have
The-
received. I have no grievances
of
left.
the present position.
Absolutely,
I
all
have-
sorted out. So kindly record his presence that I have
Well-
served him also.
Yes, record an order. Mr. Deb, learned receiver. And yes, your name, please.
Mr. Shottam Mukherjee for added. My client's name is Munmun Roy.
Shottam Mukherjee, learned advocate for added defendant number.
Added defendant number. There is no amendment to the cause title
That's
because
why I could not
Added
serve.
defendant, what is her name?
Munmun Rai.
Munmun Rai
Munmun.
are present in terms of order dated 29th August 2025. Learned receiver has handed over the charge, necessary documents.
But this was subsequently corrected also. Lordship would seize, my lord, my letter.
Yes, no, I'm considering your letter.
Yes, the letter
Still trunk.
letter
is-
records the fact that there are other orders also which were
Yes,
passed
to the register original site, which is acknowledged by letter dated September 4, 2025. Thus, the learned receiver is discharged.
already discharged, my lord.
Discharged
Lordship need not
and-
record again.
Already.
Discharged and have complied the direction in terms of order dated 29th August 2025. As the learned advocate for the added defendant has appeared, necessary communication may be made from his end also to the parties.
I have done it. I have done it today.
Already done.
Now.
Already
That has been made also.
Learned advocate for the defendant number, added defendant is present,
Has also been communicated.
and he has also been communicated by the learned receiver.
And kindly, my lord, record that the parties, my lord, whose names are appearing in the cause title, they have also been served. That's all, my lord. Because I have served. That's a copy I have.
Served, last line ta bolun to ki likhlam?
Only thing Lordship can record subject to correction that the communication of
Has
the
been communicated by the learned receiver along with the other parties to the suit.
to the other parties. Communication,
Along with the other parties to the
yes,
suit.
communication of discharge has been made.
So the necessary order with regard to communication has also been made by the learned receiver.
But they have not received, and that need
Whatever
not be.
it is, you
Yes,
have done
I
your
have a
part.
copy. I have, yes.
Sir,
Suit is already disposed, so no further order is
this is for
required.
default.
For default 2 years
Yes,
back.
yes.
I'm grateful, my lord.
I'm grateful, my lord. Thank you.
Number 7.
I appear for the plaintiff. Your lordship's last order was that the registrar of companies to produce a report. Your lordship may recall that matter, Mr.
Yes, yes.
Sen was there. So that report we hasn't come yet.
Let me see the order, please.
2nd August. I don't know, is পরে order হয়েছে?
একটা order আছে এরপরে. It was taken up on some other day, my lord, after 2nd of August, but it was adjourned because the report had not come.
So 2nd October, no, 26th August, the matter was put up.
Yes.
So let me see the, yes, 2nd August, the order was passed
Yes.
with a,
Page 17, man. এটা কে জানিয়েছে?
yes,
registrar of
so
company?
the report
জানিয়েছে?
ought to have been produced on or before 26/8/2025.
We had communicated this order to the, my lord, registrar of
On or
companies.
before 26/8/2025. Is there any appeal against this order?
Not that I know of.
So this order ought to have been complied.
Well, let them give another
My lord
notice to the
permits us to,
registrar.
my lord, write to the registrar of companies.
So
We
let
had
me-
issued a letter to the
Now
registrar
let me
general.
send a representative from this court, a special officer, to ascertain the position and if necessary to
Now, the
collect the report.
order has to be communicated to the ROC, the
Yes, yes.
register of
So
companies.
necessary
They have,
communication be made by the special officer, okay? And
let the
him-
advocate on record
Well,
of
we
the
shall do that,
defendant do it. And your lordship
Permit
keeps
us
it
to,
after the
permit us
vacation.
to, my lord, write, make a representation to the registrar of
Not
companies.
represent,
Yes,
to
record
just
an
forward
order.
the order.
And, my lord, give this order, yes.
learned advocates for the parties are present. As the
Sorry, wrong term.
report in terms of order dated 2nd August 2025 is not submitted in court, the matter stands adjourned till 25/9/2025.
No, well, after the vacation.
The matter stands adjourned till
1st November.
27/10/2025. Learned advocates are requested to communicate this order once again to the Register of Companies.
But only in the 2nd August, I find my learned friend's name has not gone down. I don't know how it will be
Let
incorporated.
the names of the learned advocates, which was not recorded in order dated 2nd August 2025, be recorded.
Great.
I'll give the name, my lord.
Yes.
Great. 27th. my lord.
27/10.
27.
Item number 8.
I appear
for the defendant.
I appear for the plaintiffs, my lord, in this matter.
Yes,
My lord,
item number
in
8.
terms of my lord's order, my lord, the learned register of this honorable court has filed a report with regard to the impounding of a document.
Let me see.
Lordship, on the last occasion, we have been provided with a copy of that report, Lordship. Lordship, that report contains an e-assessment slip by Lordship kindly takes up the report filed by the learned registrar. My lord, that report contains one e-assessment slip from the Register of Assurances, Kolkata, my lord, for the purpose of assessing the valuation of the property, my lord. And my lord, in that assessment slip, my lord, some details are there which are not correct, my lord.
No, just a minute. This is the-
Such as
As
lordship,
per the report is yet to come. Okay.
Lordship, the e-assessment slip, my lord, provided by the Register of Assurances, Kolkata, my lord. May I hand over the mic?
No, let me see on which date it is passed.
21st of
25/7. 25/7, the last report was submitted.
May. আরেকটা রিপোর্ট আছে 22nd আচ্ছা আমাদের কাছে এটা নেই
First page 10.
ও আচ্ছা আচ্ছা ঠিক আছে
Yes, it was stated that total stamp duty payable was 13,94,000 something, and total registration fee payable is 1,99,155.
Lordship, I'm not on that, Lordship.
Yes.
Lordship, the report contains one e-assessment slip.
Yes,
Kindly have a look at the e-assessment slip,
yes,
Lordship. Lordship, I am on the detail of the property.
yes.
Lordship, the property is not located on the main road, my
Now
lord.
the question is, you see, if you want to challenge the assessment, there is a forum. This court cannot go into the merits of the assessment.
Lordship, I have also obtained.
No, whatever it is, you see, once a stamp duty is assessed and a report is submitted, either you comply it or you go before the higher forum, before the appellate authority.
Lordship,
These are the two alternatives.
Lordship, the detail of the property is not correct in this assessment slip, my lord.
No. Question
Lordship,
is, whatever the entire this thing agreement was sent. Anyway, if you are aggrieved by whatever it is,
Only, my lord, the e-assessment slip, my lord.
you see, there's no question of going into these details. Once this thing
Because, my
stamp duty
lord,
is assessed.
based on the details of the property, my lord, the valuation of the
Whatever
property
you
is
see,
calculated.
the agreement for sale,
Yes, my lord.
whatever it contained, on that basis, the stamp duty was assessed. Okay. Whatever the agreement, there is a procedure for assessment of stamp duty that is followed.
Yes, my lord. After going through this, my lord, report,
Now
we
you
have
see-
also obtained, my lord, an e-assessment. My lord, kindly have a look at this.
Yes, give that.
Huh. The total valuation of the same property, my lord. The same, everything are the same. Only, my lord, the property is off-road. And, my lord, this is a sketch map, my lord, with
No,
regard
what
to the
is this?
location.
No. Question is, let us see, what is this one?
This is also an e-assessment slip, my lord, provided by the same office, my lord.
Yes, with regard to which property? Same property?
Same property, my lord.
Where do we get that?
Yes, my lord. Land details, my lord. Land details.
No, just a minute. Yes.
In the first page, my lord. Land details. District Kolkata, Thana Park Street, Corporation Kolkata Municipal Corporation Road, AJS Bose Road, Road Zone, Moulali Moor, Bekbagan Crossing, Here, my lord, the off-road. And in the other assessment slip, which was provided by the learned registrar, that is on road. Actually, my lord, the property is located off in a lane, my lord, which is a 6 feet width, not on the main road, not on the Ejesebos road.
Where is that agreement for sale? Have you stated there on the basis while you furnish this information? Okay,
Yes,
this is
Lord.
your information.
Yes, this is mine.
But you see, when that agreement for sale is given, in this case, this agreement for sale was not before the assessing authority.
Lordship.
But prior to that, that agreement for sale was there.
Yes,
You
Lordship.
see, whatever you want to do, you see, on the basis of the reference made by this court, on the basis of that agreement for sale, the collector has come to a findings. Okay.
Yes, my lord.
But in this case, that agreement for sale was not there. So whatever the collector thought fit, they have given you a general assessment. But this is a specific in nature. Now the question is, now either you comply or you go before the higher forum, that appellate authority.
Lordship, in that event, my lord, may I take out an application, a proper application in this regard before your
Anyway,
lordship,
I am
lord?
granting you opportunity to comply this. If you are not willing to comply, if you are aggrieved, then you go before the, I am keeping it after vacation. Yes.
Your Lordship, on the last 3 occasions, my learned friend has taken time on the ground that they want to take steps in accordance with
Yes,
the.
yes, yes.
My lord,
Order, order.
only on the last
Learned
occasion we have
advocates
been
for the
provided with
parties
this
are
copy of the
present.
report, my lord.
It
It is
appears
only on the last
that
occasion
in terms
we have
of the
received this.
earlier order, the Register of Assurance have obtained the assessment of stamp duty with regard to the agreement for sale. It was under which exhibit?
Uh,
An annexure, Your Lordship, and we've challenged
Which annexure? Which annexure?
we've challenged the
This-
execution of that agreement for
Okay, agreement for sale. And আচ্ছা বলুন তো কি লিখলাম?
annexure B of the plaint, Your Lordship.
yes, lord.
With regard to the agreement for sale, which is relied on by the plaintiff. Thus, the stamp duty assessed is rupees 13,94,083, and the registration fee assessed is 1,99,155. Stop. Learned advocate for the plaintiff submits that there are irregularities in the assessment of the stamp duty by which he is aggrieved. Stop. Upon hearing the learned advocate, this court is of the view that as the stamp duty is assessed by the collector in terms of the order passed by this court cannot go into the merits of the assessment of the stamp duty. In the event the plaintiff is aggrieved by the assessment of the stamp duty, he may move before the appellate authority or he has to comply the same. Let this matter appear on 3/11/2025 for necessary steps by the plaintiff.
Grateful, man.
My lord, I'm afraid in this matter. By the order dated 14th of August,
Yes,
2025.
item 10.
Item number 9, my lord.
Item 9, yes.
2025, your lordship had allowed my being implemented as a party. However, when we have placed the amendment before the department, there are 2 defects which we have subsequently discovered, my lord, for which a little clarification needs to be made in the order dated 14th of August. Yesterday, your lordship had indicated that there is some report. I believe that this is for the same only, that why the amendment is not being able to be carried out.
So the case number is mentioned as CS 24 of 2016 instead of CS 24 of 2013.
My lord, if your lordship
That is
kindly-
one thing.
Yes, my lord.
And the same error has also been made in prior A of the petition being GA 4 of 2017.
My lord.
So
The order has been passed in accordance with the master summons, my lord.
Yes.
If your lordship kindly takes up my master summons, your lordship will see that in the prayer A, only the year of the case is mentioned wrongly, my lord. So it should be CS 24 of 2013 instead of 2016. And in the order, the date of the master summons has been recorded wrongly. It should be 28th of August instead of 20th of August, my lord.
Twentieth day of master summons, 20th day of August. No, ordered him
20, it should be 28 March 2017, my lord, instead of 20.
28th day of March 2017. Yes, record an order.
My lord, just one indulgence. May a period of 2 weeks be extended, my lord, for being carried out
Learned
the amendments.
advocates for the parties are present. This matter is put up for necessary rectification of order dated 14th August 2025, passed in GA4 of 2017. It appears in the order dated 14th August 2025 that the date of the master summons is mentioned as 20th day of March 2017, which should be rectified and made as 28th day of March 2017. Secondly, in the prayer A of the master summons, the case number is mentioned as CS number 24 of 2016 instead of CS number 24 of 2013. Thus, the case number be rectified and corrected. Stop. Other contents of the order dated
14th August.
14th August 2025 remain unaltered. The time to carry out the amendment is extended by 2 weeks. The verification be made within 1 week thereafter.
So grateful, my lord.
No, to dispose matter, clarification and rectification.
May I please, Your Lordship? Mana, this is an app.
This is your application.
Yes, Mana, this is an application for substitution, Mana.
Let me see.
Now, what happened in this matter? During the pendency of the GN number 269 of 2024, the applicant Dinabandhu Patra died, and
Year 269 of
269 of 2024
yes, it was by whom?
by Dinabandhu Patra. And
Dinabandhu Patro.
yes, Mana, I have annexed the
Yes.
death certificate.
Dinabandhu Patro.
Hold on. At page 28, Annexure B.
Yes.
And in his place, let the name be of Arati Patra and Shogata Patra be
Dinabandhu Patro took out this application for
for additional party.
in which application? It's all for addition of party.
269 of 2024.
269 of 2024. By whom was this application taken out?
Dinabandhu Patra
No, Dinabandhu Patro took out this application.
for additional party.
Addition of party in which case? In this
CS number 978 of 1935. I've stated in page 7, page 17. And lastly, Justice Patnaik has asked, directed us to serve the copy to all the parties, my lord.
Yes. Yes.
Yes, my lord, Dinobandhu Patra, he filed this application, my lord, GA 269 of 2024.
Yes.
My lord, he was not a party to the suit.
That
My lord,
addition of party application.
Addition of party he took out.
yes, my lord, this
So that
application,
application has not yet been disposed.
no,
So
my
it
lord,
has to be
this
disposed.
application is out of time, my lord.
No,
After
the substitution application.
substitution application. You also kindly come to page 28. Date of death is, my lord, January 20.
Page 20.
27th of January 2025.
27th of January 2000.
Page 28. Annexure B.
And I have stated that
This application was filed.
application was made when the substituted
27/1,
application
2025. Okay.
Left hand side here, also kindly see
Yes.
at the top.
And this application
And this
taken out.
application was filed, my lord, on 24th of, it is affirmed on 24th of July.
Paragraph কত এটা?
Even it is, my lord, for 150 days.
As stated in paragraph 6, your lordship may please to see that the present petition applicant actually did not know about the case, that is GN number 269 of 2024, which has been filed by the predecessor, and the same suit is pending.
Yes. Learned advocate for the applicant and learned advocate representing the receiver is present. Our learned advocates on GA 284 of 2025. This is an application for substitution taken out by the heirs of one Dinobandhu Patra, who is an applicant in GA 249. 269 of 2024. Stop. During the pendency of GA 269 of 2024, the applicant Dinobandhu Patra died, and this application is taken out for deleting his name and with a prayer for substitution. Stop. Although there is delay in filing this application, but sufficient cause is shown for condoning the delay. Thus, the delay in filing this application is condoned, and the prayer of the petition stands allowed. Let there be an order in terms of prayer A, B, C, D, E, and F of the notice of motion dated 13th of the master summons dated 13th day of August 2025. The amendment be carried out within a period of 2 weeks, and the re-verification be made within 1 week thereafter. This application stands disposed.
I am obliged.
Your Lordship, I am seeking for adjournment on behalf of the applicant. Your Lordship kindly takes up the matter after vacation.
11 and 12.
Yes, Your Lordship.
You are for?
For the applicant.
Applicant.
Applicant intervener.
11 and 12 both.
Yes, Your Lordship.
You are for?
I appear for the Maharani.
Yes. Record an order.
Your Lordship, I am appearing for respondent number one of the major beneficiaries.
Okay. The applicant is seeking time. Learned advocate for the applicant and learned advocate for the you are for respondent.
I am for the
one of the trustees.
Yes.
One of the trustees.
One of the beneficiaries.
One of the beneficiaries, and learned advocate for the respondent are present. Time is sought for on behalf of the applicant. Such prayer is allowed. Let this matter appear on 29/10/2025.
Obliged, Your Lordship.
800.
Thirteen minute I appear for the petitioner. But I am for the applicant in 13.
14 is my application.
Yes. 13. 13 is GA15.
GA15, it is for addition of party, my lord.
Let me see the application.
Partition suit, my lord.
No, let me see.
Lordship.
Plaintiff is absent.
Prior to that, my lord,
Yes.
there are certain developments. During the session of this matter, a portion of the suit property has been rented out by one of the co-sharers, and which could not have been done in the first place because now the partition commissioner is also there. And it has come to my knowledge, and my
that
client
is
has
your
informed.
petition. It
No,
is
it
your
is his petition. My
No,
petition
this
is the-
petition is for addition of party.
No, addition.
If you have any grievance regarding development, you have to take out an application, give other parties an opportunity to deal with that.
That is already in 16. That I will-
16, that is there. So that will be taken up.
Yeah.
Yes, regarding, yes, what is your status in this suit
My lord,
property?
I tell you, lordship. My lord, initially, my lord, the property belongs to one Pyari Mohan Mulli.
Yes.
Now, my lord, there are 4 suit properties, my lord, in this particular case. Now, my lord, one is the dwelling house and other 3 are the rented accommodation. My lord, those are my lord, completely tenanted. Now, my lord, what happened, my lord? This Pyari Mohan Mullik, my lord, executed a will. My lord, under the will, my lord, the Pyari Mohan Mullik had 2 wives. Now, my lord, under the will, my lord, he gave, my lord, 1/6 share to 4 sons of the first wife, and my lord, the second wife, another 1/6 portion, and my lord, the son of the second wife, another 1/6 portion. So total there are 6 shares, my lord, in the dwelling house according to the will. And my lord, other properties were divided, my lord, in 1/5 share, my lord, in between, my lord, the 4 sons and of the first wife, and my lord, the second wife. So there are 1/5 share, my lord, of each, my lord, in the other tenanted accommodations. Now what happened, my lord? This will was probated. My lord, under the will, my lord, one Robindranath Mullik, who is the son from the first wife, my lord, got, my lord, 1/6 share in the dwelling house, and my lord, 1/5 share in the other properties. Now, my lord, Robindranath Mullik was not, my lord, added as a party, my lord, in the suit, my lord, because, my lord, my lord, the plaintiff, my lord, say, my lord, that he has died intestate, my lord, without any issue.
Now, my lord,
my contention is.
Please let him complete. Please.
My lord,
No, he is submitting on this application.
my
Have
lord,
you filed your opposition?
application cannot be heard today.
Have you filed your opposition?
Yes, my lord, but he had a direction which he did not comply. Perhaps why I am wasted? The judicial time should not be wasted.
No, let him complete. Thereafter, you make your submissions.
Now, my lord, if your lordship, my lord, kindly takes up the application once. My lord, if your lordship kindly takes up, my lord, the death certificate of, my lord, what happened, my lord? This Robindranath Mullik, my lord, is the son of the first wife of Pyari Mohan Mullik. My lord, he is having 1/6 share in the dwelling house and 1/5 share in the other tenanted accommodations. Now, my lord, they have not added Robindranath Mullik. Robindranath Mullik died, my lord. My lord, page 14, my lord, is the death certificate of Robindranath Mullik.
Yes.
My lord, Robindranath Mullik died on
Page 14.
page 14 of my application, my lord.
What is this application? Is what? GA16?
GA15.
GA15 ta din.
GA15 is my application for addition. So your lordship will find, my lord, at page 14, annexure B.
Yes.
My lord, this is the death certificate of Robindranath Mullik.
Yes.
Now, my lord, your lordship will find, my lord, the date of date is 11 February 1996.
Yes.
My lord, this suit was instituted, my lord, in 2014.
Yes.
Now, my lord, the wife of Robindranath Mullik, my lord, your lordship will find the death certificate of the wife of Robindranath Mullik, which is appearing at page 13.
Yes.
Date of date is 18 January 1987.
Yes.
Now, my lord, what happened, my lord? We are six applicants. We are the heirs of the Robindranath Mollik and Kollani Mollik. My lord, what happened, my lord? They have not aided us in the partition suit, and my lord, they have said. The plaintiff has stated. The plaintiff has stated that Robindranath Mollik died, my lord, without any issue. He has not married.
No, partition suit was filed prior to the death of Rabindranath Mollik.
No.
Or after the death.
2014.
No. You are telling that this partition suit filed in 2013.
14.
2014. Okay, and this Rabindranath Mollik died when?
1996.
1996.
Yes. Now, my lord, what happened, my lord? The six applicants, my lord, in GA15 are the heirs of the Robindranath Mollik and Kollani Mollik. Now, my lord, what happened, my lord? The original plaintiff, who has now died and have been substituted, my lord, the original plaintiff had not added, my lord, us as a defendant in the suit. My lord, we thus have filed this application for addition of party. Now, I have certain documents to show before my lord that we are the, my lord,
So it is there in the record?
Yes.
The documents?
Yes.
Yes.
Now, my lord, they have disputed that Rabindranath Mollik has died without any issue. He has not married. So they have not added Rabindranath Mollik as party, and they have therefore, my lord, divided, my lord, 1/5 share of Rabindranath Mollik amongst themselves. My lord, in doing that, what happened, my lord? The one of the daughter, my lord, who has a live interest in the property, my lord, his son, my lord, is claiming a share in the property, who otherwise is not entitled. Now, my lord, my share is being divided, my lord, amongst these, my lord, other plaintiffs and defendants. My lord, even when, my lord, I am the heirs of the Rabindranath Mollik.
Anyway, the documents which you are
Yes.
relying upon with regard to the will and the will with regard to the death, that you have annexed.
My lord, death certificate I have annexed.
Yes.
Your lordship will...
My lord, kindly, for a once.
No,
kindly
no, once. Let him complete thereafter.
No, my lord.
No. Where is the order? Where is the order granting probate?
Order granting probate. My lord, that is in the plaint, my lord. If your lordship...
No. Why have you not annexed it here?
My lord, my lord, that, my lord,
Anyway,
is not with us.
So, which paragraph you have stated that regarding grant of probate?
Lordship. No, that is not specifically, my lord, stated in my application, my lord. Your lordship will find, my lord, that we came to know about the suit, my lord.
So better you file a supplementary affidavit, come on the next day.
No, my lord.
My
lord, kindly now I join
Yes,
the
record and order.
Kindly, my lord, 20th March 20th March order, my lord, kindly have a look.
Is it there in your opposition, that order? Have you filed it, your opposition with the document?
They were required to give me inspection.
Question is, have you annexed that order?
How can, my lord, 20th March published by this honorable court? 20th March of this honorable court order, my lord.
No. Question is
20th March 2025.
Question is, you see, let him file a supplementary affidavit. You have filed your opposition. If you have to disclose any other documents which by virtue of development, then you file it
My
in
lord,
your opposition.
I bow down. Just one line, my
March
lord.
Is where is that order?
My lord, 20th March 2025 passed in this suit. My
Yes.
lord, may I have the copy?
No, give a copy.
20.
Anyway, you enclose it in your opposition.
What was the direction upon them, my lord?
Very well. What is the difficulty to file it in your opposition?
My lord, the difficulty is...
No, if that order was passed during pendency of this application.
Yes, in respect of this application only.
Now his application, it is his application.
Yes.
Something is incomplete, let him take steps.
He already filed a supplementary affidavit. And in the supplementary affidavit, he attached some new document. I took an exception. Then there was a direction upon,
Yes, record and order. Learned advocates for the parties are present, hard learned advocates in GA 15 of 2024, as certain facts are not disclosed in this application. The liberty is granted to the applicant to come out with a supplementary affidavit with a copy upon the opposite parties. Let this matter appear
after vacation.
on
Let it appear prior to the vacation. I will
on
take your Lord for 1 week time.
27/10/2025.
And my lord, what goes to about my inspection which I was granted by this
Anyway,
order?
My lord, no inspection was granted.
Yes, my lord, kindly see
No
the
inspection was
order.
granted.
no. In the event any earlier order is passed directing the parties to give inspection, that has to be complied with.
My lord, let them show my lord to my lord that inspection order is
Yes,
there.
may I read it out?
What happened?
I have clarified, in the event there is an order directing the parties to give inspection, that has to be complied with.
It was the query of the court to place the records before the court.
If there is
No,
no
for inspection by the plaintiff.
if there is no order, then no question of compliance.
For inspection by the plaintiffs, it has been mentioned.
My lord, the learned advocate commissioner, partial commissioner in this matter. Here, my lord. But pursuant to your earlier directions, lawsuit direction, certain activities that it is continuing to do of maintaining the property, making regular visits to the property, cleaning of the property, collecting. But the last remuneration of the learned receiver was paid sometime in the month of March. I was praying, my lord.
My lord, I have strong objections to this. I would not have because I have taken out a specific application recalling the order of appointment of the partition commissioner, because this was done behind my back, and that is exactly GA 16. Now, what has happened in the interregnum? May I kindly indicate? May I kindly?
I'll take up your application.
My lord,
Definitely.
may I kindly indicate what has happened during the session of this matter, my lord? Tenants have been inducted.
I shall take up your matter.
House, not only that, my lord.
I'm just taking up your matter. Okay, just let me clarify. As it is submitted on behalf of the learned partition, on behalf of learned advocate commissioner, on behalf of the learned advocate appearing for the partition commissioner, that last remuneration was received in the month of March. Let further remuneration be paid till the month of June, without prejudice to the rights of the parties.
Lordship, it is draining our common fund.
No, it is already fixed by the court.
Last version, 1,000 J was been paid.
Okay, let a remuneration of 1,000 gems be paid. Yes, now let me take up your application. Yes, GA 16. GA 16 টা দিন। ও দেওয়া আছে এখানে। Yes.
My lord, may kindly see, this is a partition suit of 2014. Thereafter, I am defendant number 10. I appear in the said suit and file my written statement way back sometime in 2016.
What is your application for?
My lord, this is an application whereby I have sought recalling of the order by which the partition commissioner was appointed. My lord, may kindly come to the order which is annexed at page 15.
Page
15.
15, yes.
My lord, may I kindly place? This is an application by one of the defendants, the other co-sharer. GA 14 is filed by the defendant number 12, praying for appointment of partition commissioner for allotment and demarcation of land and structure. Now, kindly take note of it. This was their specific pleading why they wanted the partition commissioner, as described in the schedule of the plaint in favor of the plaintiffs and the defendants according to their respective shares on the basis of preliminary decree, which was passed way back in 2016. So on 2016, my lord, at least with respect to the proportionate shares in the property, undivided property, there was no confusion. There was no objections against the application on behalf of the defendants. Now, if this order is to stay, then it would presume that all the defendants have been served. This application is taken out in a suit which was filed in 2014. I enter appearance by filing my written statement it is at least expected that the defendant should serve upon, or the whoever is taking out an application should serve all the defendants or the interested party. Let them show how they have served me.
Yes, now, yes, thereafter. So
Mr.
this order was
So-and-so, a
passed
member of
30th
the-
April. Okay. Yes.
Now, my lord, thereafter, what happens is a subsequent order of 19 July 2024.
Okay, this order was passed without giving you an opportunity of
Yes.
being heard. Okay. Now let us see what are the other grounds.
My lord, this is my primary ground.
Okay.
That I should be
So
put on.
this was passed when? That is
This was
30th April.
This order was passed on 30th of April 2024.
Okay.
And soon after I came to know of this order, I preferred an application in August.
Yes.
And in the meantime, there was payments which was made to the partition commissioner.
You are for the defendant number 10.
I am for the defendant number 10. Now, my lord, may kindly see what has happened. The partition commissioner has not taken any steps.
So let me see your petition. So this is the order. Okay.
Yes, my petition.
So this is their your grievance is this. You are not been served. Okay.
Yes.
Next 7 para. Okay. Then thereafter, what are your allegations?
This was at the point when he was appointed, when the partition commissioner was appointed. Soon thereafter, I took out this application. After that, what has happened? After that, on a regular basis, the partition commissioner has been filing reports, and there are serious allegations against me, to which I have drawn exceptions on each and every time. So now what has essentially happened is it has multiplied records. So the partition commissioner has filed a report. Thereafter, about a month, and
now the question is you see, this is your grievance that you are not aware. Now, any other allegations that partition, where have you stated? Partition commissioner has not taken any steps till this date. Where?
No, let me kindly see the date of the application. I could not have made those allegations in this particular application.
You could have made by supplementary affidavit that there is inaction on the part of the commissioner.
My exceptions are already there, part of the record. To his report, my exceptions are already part of the record.
Okay.
If all can be taken up together, because those are all part by way of affidavit.
Oh, there is an exception to the report.
Yes.
Okay, let me see the exceptions, please. Hey, exceptions.
There are several exceptions because.
Okay, 2024. How many reports is filed?
He would be able to.
No, you have taken exceptions. You should know.
If I'm not wrong, I think on 5 occasions he has already filed reports.
Some bit of responsibility. I think it's a senior member of the bar.
No, it's not about senior member of the bar. Please, this is about the partition commissioner. That is why I did not even read out his name. No, I did not even read out his name.
Let me see.
No, this is not a. No, this is not a personal battle. This is not a personal battle with him.
Please let me see an exception. And which have you filed any affidavit?
Yes.
That tenants have been inducted. Which?
That would be evident from his report.
No. Let me see.
Evident from his report.
Okay. This is.
My lord, kindly also see who has inducted tenants.
The exception. Okay. Okay, the report was served upon you.
Yes, all reports have been served.
Okay, just let me see.
And I have used an exceptions to all reports.
Okay.
And not only that, in the presence of the partition commissioner now, I can't even call them a tenant. Someone has been inducted and making changes to the nature and character of a heritage building.
My lord, all these are beyond pleading.
Beyond pleadings.
Kindly don't allow.
Yes.
Just a minute, please.
I will support it by way of pleadings.
Let me see.
because this is being done in absolute support of some of the parties who do not stay there. None of them stays in the dwelling house. If my lord so directs, I can use a comprehensive supplementary which would cater to everything, all my allegations. I can do that or take out.
Now something has to be done. The suit has to be disposed. The property has to be partitioned by meets and bounds.
My lord, for this,
Or-
my lord, my application has to be heard.
Yes, yes, yes. Or the property has to be sold in auction.
Absolutely on that point.
This is the only two things.
Multiple properties. The partition commissioner has not taken any steps towards partition.
Well, it cannot be taken, my lord, because my application has to be heard out first.
He's only.
Are you in possession of the property, in any portion of the property?
I am, my client.
Yes.
No, my lord. They are not in possession, my lord. My lord, according to us, my lord.
My lord, even in the dwelling house, only I am in possession. Rest of them, they do not even stay in the dwelling.
Because he has ousted all of us.
Ousted.
Yes.
Ousted.
Yes. You have ousted your own
Yes.
mother.
Yes.
He has ousted his own mother. His mother had to approach this honorable court.
Let him say whom is he representing and where is he getting such pleadings. The connivance is apparent. I need not submit anything more.
This is.
Defendant is being represented by the plaintiff.
Okay, these are the exceptions to the commissioner's report.
Yes.
This may be taken into consideration.
Yes.
First of all, the appointment.
For the interest of justice and so that, because now what has happened, there are multiple pleadings.
Yes.
Because the commissioner has filed at least 4 or 5 or maybe 6. I would stand corrected by my learned senior friend. I think at least 5 he has filed reports, to which I have used an exception. Now, my lord, in a partition suit, there are 2 stages. The first stage we have covered, the preliminary decree. If my learned friend's application goes, then that preliminary decree remains.
Have you filed any opposition to that application for addition of party?
No, I'm not objecting to that.
Okay, you are consenting to this application anyway. Yes, then.
So if his application is allowed or disallowed, whatever be the fate, if it is disallowed, then that preliminary decree holds ground, and all that remains for the partition commission.
Yes, to partition by meets and bounds, or there will be auction sale. These are the two things.
Because there are 4 properties which have been identified, and my lord, to this day, from the records it would show it has been at least over a year now. He has not taken any steps for partition. What he is actually doing, and I should put it on affidavits because or else it would be a oral submission. I do not want to do that. Let me put by way of an affidavits the allegations which I have.
May I, my lord? May I? I am the plaintiff. May I?
He is the plaintiff. It doesn't
Yes.
right. It's
No.
a partition suit.
I know.
It's a partition
I know.
suit.
I have not disturbed you kindly.
Yes.
My lord, first of all, in our original side practice, normally no application is being taken for hearing unless and until the court is satisfied that all the parties have served. This is one thing. Second thing, my lord, admittedly there is a preliminary decree. Now, this application is nothing but a browbeating to the court in the disguise of an application. Why? My lord, kindly take Order 26, Rule 13 once.
Which application?
Order 26, Order
Yes,
26.
yes, yes. That is appointment of the commissioner.
Yes, my lord.
Yes, you just go through the.
My lord, Order 26, Rule 30. May I please? Commission to make partition of immovable property. Where a preliminary decree for partition has been passed, the court may, in any case not provided for by Section 54, issue a commission to such person as it thinks fit to make the partition or separation according to the rights as declared in such decree. Now, procedure for commissioner. The commissioner shall, after such enquiry as may be necessary, divide the property into as many shares as may be directed by the order, etc., etc. So what is my take away from this? My lord, admittedly, there was a preliminary decree in 2016.
No, question is, you see, I'm not going into the merits of the appointment of the partition commissioner, okay?
Absolutely.
I cannot, without hearing you, all the parties, I cannot go into the merits of recalling that order. So, an opportunity is to be granted to your learned friend to come with a comprehensive affidavit about with regard to the report submitted and subsequent developments.
My lord, I will go to that extent. I will go to that extent. I'm so grateful to my learned senior friend who has pointed it out. And his opening lines was, in our original site practice, it is deemed that all parties have been served before taking an application. That was his opening line. Yes. And I will borrow from that, and my grievance with respect to appointment of that partition commissioner on that day was limited to the fact that I was not put on notice.
Not required. No application is not at all required.
But
It is the court's duty to appoint the partition commissioner.
Learned advocates, please wait. Learned advocates for the parties are present. GS 16 of 2024 is taken up for consideration. Hard learned advocates. As learned advocate for the defendant number 10 applicant intends to use a supplementary affidavit to bring into record subsequent developments, and with regard to the report submitted by the learned partition commissioner, such leave is granted. Let the supplementary affidavit be filed on or before 24/9/2025. Reply to the supplementary affidavit be filed. The opposition may be filed on or before 27.
My lord, only 3 days.
Yes,
The vacation.
Only 3 days. There, 20.
Actually, okay, but the reply, if any. No, opposition. So this is supplement opposition, if any.
Yes, my lord.
By 29/10/2025. Reply, if any, by 4/11/2025. Let this matter appear on 10/11/2025.
My lord, till then, the nature and character of the suit.
There is already a restraint order. There is already an order.
Learned partition commissioner is requested to see that there is no alteration of the suit property.
Only one thing, my lord. There is a some repairing is required.
That repairing is not changing the position.
That may be mentioned in this order. Otherwise, why
No, my lord. My lord, there is no application for interim order. There is no application. He is actually getting an interim order in the guise of an supplementary affidavit
It is
prayer.
the duty of the commissioner to see that there is no.
My lord, there is a restraint order already passed. That order is
That has
subsisting.
clarified. If
Yes,
they want
there
to
is a
repair,
restraint order.
If they want to repair, they have to put
There
in
is
the
a
schedule of
restraint
repair.
order. There is a
Put in the schedule of
He
repair.
has already
No,
inducted tenants.
That cannot be done.
That
This
kindly-
is the heritage structure.
No. Why are you so much scared about if I pass this order that the
Absolutely.
commissioner?
My lord, there is I am not at all scared.
It's pat on the point.
The problem is, he has already inducted tenants. There are tenancy agreements
I have
which
already
are
disclosed
already,
in opposition.
which are
I have already disclosed.
Essential repairs, if any, may be done upon notice to the partition commissioner.
But a copy of that.
My lord,
24/9. and opposition by 29:10 and reply if any by 4:11. Matter to appear on? Yes, 10:11.
My lord, unless
Served upon the learned commissioner, so he cannot.
Yes, copy of the affidavit shall also be served upon the learned partition commissioner.
my lord, since there is a restraining order, now what has happened, my lord, if I may kindly indicate, unless they appeal before this honorable court, seek leave to, because this is like any other suit, an injunction with respect to nature and character of the suit property is the first order.
Come with the specific points and suggestions on the next day. Leave this ego problem.
No, Lordship,
These are all ego.
We should all
suffering from ego problem.
My lord, we should
Leave all these ego problems.
It is due to only him.
He does not even stay there. He does not even stay there. He has inducted tenants.
Yes, no,
He
I am
himself
not.
has
You
inducted
are.
tenants.
You are the main culprit.
If he does not say, the court will not take into cognizance. No question.
If I have
do not
inducted
know
tenants,
such
my lord,
unparliamentary language can be used by a senior member of the bar.
Anyway, come on the next day.
if my lord, I have inducted tenants,
Absolutely
I
unfortunate.
invite an application for contempt from my lord.
Unfortunate conduct
I invite.
on the advocates of the seniors.
Anyway, call the next.
I'm grateful.
Number 15 to 17.
না 15 টা তো আমরা করে পিছিয়ে গেল তাহলে 15 I appear on with the joint receiver, my lord.
15, whose application?
The application filed by the state of West Bengal, my lord.
No, your lordship kindly.
No, GA 238.
Yes.
State's application.
No,
Yes.
state.
So move that application. The affidavits are complete. No, GA 238 is your application.
No, we have filed opposition. They have not filed reply as yet. Those specific time limit was granted twice.
That's not the direction. On that,
Within time.
What has happened? While clearing this, we have found some old documents relating to ST. Those are.
Oh, within which time can you file? Because you have obtained adjournment on the last occasion also.
Not be embarrassing, your lordship. That is one final time for 10 days. By end of the next week, will be paid.
So all three cases, 15, 16, 17.
No.
And 16 and 17 not your.
Dependent on the outcome, because I'll be showing those records.
No, my lord.
No. Steve, this thing GA 276, whose application? It is your application.
Yes, Lord, for sale.
What?
My lordship was for permission to sell.
76.
Yeah.
There was a decree by this Congress. Which had clearly indicated what extent the sale can be made.
Okay, better use to GA 276. Please serve a copy upon the state. Otherwise, again there will be problem.
Everything is ready.
No. Have you served a copy?
Hearing was also concluded by my lord was going to pass
This
order. Then they intervened.
276.
Yes. Yes, my lord was going to pass order. 17th June. 11th June 2025, your lordship, can you see the order? 11th June.
Just a minute. 11. Okay, let me record this order first. Item 15. Learned advocate for the parties are present. Learned advocate for the state prays for time to submit affidavit in reply. Such prayer is allowed. Let this matter appear on 22/9/2025.
11 June, 20 June, Lord, your lordship, can you see that they were directed to submit report. Even the division may discarded, the report was rejected.
No, I'll come with all this.
Yes, now with regard to GA 26, let me see the order, earlier order,
Yes.
whether state has been served or not.
Yes, 11th June.
GA 276 এর এই 16 নম্বরটা
271.
কবে আছে এটা? For orders?
Yes.
No. No, whose application? GA 26, your?
Yes.
Okay, just a minute. Let this matter also appear on 22/9/2025. 17 also same order. Let this matter appear on 22/9/2025. For orders. ওটা কি ইয়েতে পাঠান না? Was concluded?
Yes.
Yes. Okay, it will appear on 22/9.
Order document 18.
Hello.
I am appearing for the defendant.
I appear for the plaintiffs.
Yes, upon, yes, yes.
Of the suit property.
Yes.
Your lordship already.
No. Considering the facts and circumstances, this court is of the view that a special officer should be appointed to ascertain the market value of the suit property, and upon giving the necessary particulars of the suit property, including the age, before the register of assurance, the market value should be obtained, and upon obtaining the market value of the suit property, the report should be submitted on or before 22/9/2024. On 22/9/2024, the matter will appear for report. And upon considering the market value, the decision will be taken, whether for auction or whether the parties will be permitted, the decision will be taken.
What is the date of the that was
20, no. Today's order.
Today's order.
Matter will appear on 22/9 for report.
Your lordship.
Beg your pardon.
Yes.
When is the next?
22/9 for report. No, let it appear as to be mentioned. To be mentioned,
It will appear as to be mentioned.
To be mentioned.
Your Honor, I have certain applications which are to be.
Come on 22/9.
Okay.
Document 19.
Mr. Metro has requested my lord to fix it next week. A note has been prepared.
Mr. Dotto, have you completed your submission?
The hearing was concluded, or it is only my lord to file the notes of argument by the parties.
Mr. Thakkar is to give the reply.
Mr. Thakkar, led by Mr. Surajit Nath Metro. Mr. Metro has requested to keep it on next week, anytime convenient to your lordship. Fix any day, any time.
Yes, item 19. Learned advocates for the parties are present. On the prayer of learned advocate for the plaintiff, the matter stands adjourned till 15/9/2025 under the same heading. আচ্ছা 15/9-তে দেখুন তো ইয়ে আছে কিনা কোনো দুটোর সময়।
Virtually, the hearing was concluded. Virtually.
Anyway, reply just.
I am not standing.
Reply
in the,
no new points.
I am not standing.
আচ্ছা। Okay, I am keeping it on 15/9/2025. আচ্ছা 10:30-তে কোনো fixed আছে কি? I am keeping it in the top of the list 10:30.
Top of the list 10:30. Yes.
Okay, I am giving top priority.
Yes.
So please conclude.
And my lord,
and written notes of argument.
My notes are ready. I will give it on that day, my lord.
Yes, 15/9/2025 at 10:30 a.m.
He may give me the
notes. Why I shall give a note? You have heard my argument.
Is there anything, something?
Yes, sir.
Not submitted there?
For trading of at number 20.
My lord, this matter for the plaintiff, this matter was supposed to appear on 15 September, my lord.
Yes, my lord, this is there in the last order that it is on 15 September. But my lord, since it has come, my lord, I have just two things to, my lord, bring to your lordship's notice. My lord, first of all, my lord, the adjournment, my lord, on the last three occasions was being sought for by the plaintiff. My lord, it was on the last occasion we did not appear, but in the order, my lord, it is somehow, my lord, recorded.
My lord,
now the matter is due to appear for framing of issues.
Yes, but there is a problem, my lord. I'll tell your lordship, they are enjoying an injunction. The plaintiff, my lord, this is a suit of, my lord, 1976. They say that they have purchased the property along with me and defendant number 6. I am defendant number 5 and there is another defendant number 6. But, my lord, actually the deed does not have the plaintiff's name. The deed, my lord, has the name of 5, 6 and the predecessors of 1, 2, 3 and 4. The plaintiff's claim, my lord, is under the Benami, my lord, Transaction Act to say that they have given the money and, my lord, the names are there They are nobody. They should have, my lord, executed a deed of release in their favor. My lord, this is the crux of the matter. Now, my lord, from 1988, I was, my lord, enjoying, my lord, an order where I was appointed the special officer, as in my brother, and defendant number 6 was also appointed special officer. Now, when my brother died, I came to court saying, you substitute me instead in place of my brother. The single bench, my lord, Justice Shogata Bhattacharya, my lord, allowed that. They preferred an appeal saying that, no, you also add me as a special officer because this is my plaint. Now, before the division bench, my lord, Justice Arijit Banerjee there, learned, my lord, the division bench said, you take a fair stand and let them also be on board and be special officer. My lord, I agreed. But, my lord, that agreement, my lord, that consent was given under the presumption that they will proceed with the suit. Kindly, my lord, just see this order once.
No, today what is the difficulty?
Difficulties, my lord. This is the third. This is the third adjournment. I, my lord, have a strong belief that they don't know whether they have a right or not in the property. Today they are enjoying an order of injunction on the property on everybody. I can't deal with my share. Defendant number 6 can't deal with his share. And, my lord, the plaintiff is also not coming and proving his case. There is no dispute with regard to my title. Now, my lord, if they don't want to proceed, my lord, there should not be any injunction, my lord, on me not to deal with my share. That is all, my lord, that I am saying. Your lordship.
Anyway, this is an old suit. It has to be disposed of.
Yes, and your lordship will, my lord, kindly observe that despite that direction of the division bench, my lord, that they are not proceeding. On the last 3 occasions, they have taken time. That is all.
My lord, if I
Now the discovery inspection, everything is over.
Thing is complete, and my lord,
So why didn't you take steps all these years from 1976?
it is their suit. They are the plaintiff.
Why didn't you
carriage
mention?
proceed.
Why didn't you mention it before the court?
My lord, we did. Where, my lord, when my brother died, I became a special officer, and I was conducting, my lord, the special officer, my lord, every accounts and everything I was taking care of. Today, I have nothing to say in this suit because they are not disputing my title. They are not disputing the defendant number 6 title. Today, before your lordship, this plaint is only there because they have to prove that they have a right on the property. If they
That
don't,
is suit for declaration. This is a suit for declaration.
yes, suit for declaration that they are the owner, they are the part owners along with me and defendant number 6 and defendant number 1 to 4, my lord, should release in their favor. Now 1 to 4 is not there before your lordship. They have filed a written statement, defendant number 1. After that he died. And, my lord, 1, 2, 3 and 4 were substituted. But nobody has come today, till date. We have served, there's a report from the register, they are not coming. So, my lord, if they can't prove their claim, I should be allowed to walk out of the property, my lord, with my right and be able
So
to
let
deal
them
with.
give it. Let them be given another opportunity.
Yes, and-
Yes. Record an order.
And
My lord, the matter is scheduled to come on 15th September. Today is not even the date fixed in the matter.
Okay. Let this matter appear on 15/9/2025, as earlier directed. Learned advocates are requested to come with necessary instructions on the said date.
my lord, not advocates, him. My lord, I have my and my lord, then
My lord, we'll file a suggested issues on the next date. My lord.
Yes, I'm keeping it on 15/9.
my lord, this let the last order be corrected. My
Yes,
lord.
ma'am.
The prayer, they prayed for time, adjournment.
My lord, that may be corrected, my lord. Instead of
That
defending
is
the
not
plaintiff.
necessary. This is simplicity adjournment.
Want to go to the appeal court, they will only show that I took adjournment.
Anyway, on the next day I shall do the needful.
They will only
This is a simplicity matter. Okay, this is not any adjournment. Does not, you see, adjudicate your rights. It's a simplicity procedure of the court.
Yes, but I'll ask for vacating the interim order at least, my lord, to my extent.
Let him come with necessary instruction on 15/9.
Then, my lord, they very well. And, my lord,
On that day, try to file the suggested issues.
Absolutely.
And others are all complete, discovery, inspection, everything.
Absolutely, my
Only
lord.
file your
My
suggested
lord, this
issues.
is a change brief 1976 matter, so we do not have
No,
all the
when did you
documents
obtain
here.
the change? Which year? This year?
My lord, 2 years back or something like that.
2 years.
We have already applied for certified copies. We'll file a suggested
Talk to
issue.
me, your learned friend. They will provide you.
Yes, ma'am.
I had offered, but they are not coming. I can give him here and now let him take a
Yes,
copy.
My lord, we'll file a suggested issues on 15th.
My lord, my
Senior
client
friend does not need to worry.
This is a luxury litigation, maybe for
Anyway, 15. Please come with the suggested issues.
Grateful, my lord.
Number
21.
Lordship, in this matter, I appear on behalf of the plaintiff.
Lordship, I'm for defendant number 1.
This is for framing of issues, Lordship. Lordship, on the last occasion, I had indicated, my lord, I am the handling advocate in the matter. So there has been a change in the person who was actually handling the matter before me. In that circumstances, Lordship, copy of the written statement of the defendant number 1 was sought for on the last occasion. That reservice has not been done yet, my lord. So otherwise, I am ready with my suggested issues, but I am to consider the written.
Lordship, we were not of the knowledge that it is a change brief. I had already served the copy. I think I have served the copy on the erstwhile advocate on record.
Lordship, last audit was there, so my learned friend can just reserve it on me once.
I will reserve it. I will reserve it.
Record an order. Learned advocates for the parties are present. On the prayer of the learned advocates, the matter stands adjourned till 17/9/2025.
Grateful, Lordship.
Great.
To come with the suggested issues.
Old item number 22.
Yes, not today.
23.
Yes, not today.
24.
Yes, same.
25.
Same.
26.
Yes. Same.
27.
It's not today.
28.
I am for the plaintiff.
28. This is GA2 is whose application?
Application
GA2. Let's see that. Yes. So let me see. Just a minute. The application is not here. If you have a copy of the master summons.
Master summons have given you.
When did you file?
Fourth.
Yes?
On 4th.
4th. Yes, give a copy of that. No, as per the master summons, it is due to appear on 11th.
Yes, on 11th.
Acha, let this matter appear on 11/9/2025 under the heading New Chamber Applications.
Section item number 29.
Yes, not today.
Item number 30.
Lord,
Section.
so far this matter is concerned, I am for the plaintiff. Well, the thing remains before I proceed in this matter. There is an order of Honorable Justice Shomen Sen. It was initially, my lord, a document, deed of assignment was there in favor of the assignee plaintiff by the original plaintiff, and thereafter the amendment had been carried out. Well, we'll kindly look at this order of the Honorable Justice Shomen Sen. Well, it is to be this document, my lord, has to be sent for impounding because of insufficient stamp duty.
Just a minute.
ঠিক আছে, ঠিক আছে, ঠিক আছে, ঠিক আছে। এটা খুলুন।
So what was this application
My
for?
lord, this is a, my lord, this is, my lord, in fact,
Application of the plaintiff.
it was an application of the assignee plaintiff for the purpose of, my lord, this substitution and for assignment recording.
Yes.
Now, my lord, amendment has been also carried out in the print. Assignee plaintiff has come in the picture. Now, my lord, so far the assignment deed is concerned. This is the deed, my lord, will kindly just look at. But it was printed on, my lord, ₹100 stamp. But the Honorable Justice says, my lord, that it is to be impounded because of the fact, my lord, that
The question is,
yes, my lord.
there is an observation, okay? The question is, question of admissibility of the said document is to be decided at the trial, okay? Now, when you tender the document at the time of trial, whether it will be admissible or inadmissible, that has to be taken into consideration.
My lord, I bow down to your lordship. My lord,
Yes.
now, my lord, you kindly look at, my lord, section 35.
Yes.
Supposing, my lord, insufficient stamp was paid, that is the reason why it is inadmissible. My lord, will kindly look at section 35 because I will be entitled to,
Yes.
under the proviso,
Yes.
to give the balance stamps. My lord, will kindly look at proviso up to section 35 of the Indian Stamp Act. That is the reason why, my lord, this impounding is necessary and this document has to be sent to the appropriate officer.
This is you are the assignee plaintiff.
I am the assignee plaintiff. Before the trial, my lord, there are other functions are there. The inspection of document will be made, and thereafter, my lord, the filing of the suggested issue. But before that, my lord, this document has to be sent for impound.
Yes, record an order.
Well, there is an officer also in the Calcutta High Court who will be entitled to check up all these things. Because section 33 also speaks of that.
Mr. Chakraborty, learned advocate for the assignee plaintiff, is present. Heard, Mr. Chakraborty. It is submitted by Mr. Chakraborty that the deed of assignment, which is relied upon by the applicant assignee plaintiff, is not sufficiently stamped. So the deed which is annexed to the application, which application for substitution?
Application for recording assignment?
Yes, no, application before this court, it was
This
annexed.
court was for recording assignment.
Yes, application for assignment
was made and allowed.
Was
for bio of
marked as annexure, and the same was not stamped. In the facts and circumstances, this court is of the view that in accordance with the section 35 of the Indian Stamp Act 1899, this document should be impounded and be sent to the Register of Assurance for assessment.
I do not think Register of Assurance, but there is
Collector.
Will kindly look at section 33 proviso once. There is an officer of this honorable court, who will decide the matter.
No, all the matters, all orders are passed in this way. Because
33 proviso, my lord, kindly, my lord. Thereafter, your lordship, whatever your lordship will decide. Second, I believe, item number 2, that is the section proviso to the subsection 2. একটা বই আছে স্ট্যাম্প অ্যাক্টের না নাই ঠিক আছে there must be an officer of this honorable court, my lord, who will take decision in the matter.
Well, it would be better, you see, when the matter documents are tendered, then the court sends it before the officer. But normally, you see, in the other matters also it is sent.
But my lord, here, my lord, the order is already there. So there is a insufficient of stamp. I am admitting, my lord. So it has to be, my lord, sent. Because there is another difficulty, my lord. After, my lord, settlement of issues and everything, I have to apply also for commission. because my witness is very much in difficult stage.
Yes, yes, yes.
So that is the reason, my lord, today is the time for, my lord, sending the document for insufficient
Let
stamp.
this document be placed before the registrar original site.
I'm grateful, my lord.
To depute an officer.
Grateful, my lord.
In this regard, for the purpose of assessment of the stamp duty, in accordance with section 33, subsection 1, clause B of the Indian Stamp Act 1899. Upon deputing a competent officer in this regard and upon assessment of the stamp duty, a report be submitted to this court on or before 25/9/2025.
Such a within time.
Okay, on 28/10/2025.
My lord.
Let this matter appear on 28/10/2025.
My lord, this document to be sent to the.
Yes. Let the deed of assignment filed by the plaintiff be sent to the registrar original site.
Grateful, my lord. May I get back the Indian Stamp Act?
Yes. এই বইটা দিয়ে দিন আর এটা রেজিস্টার অরিজিনাল সাইটের কাছে যাবে আপনি।
Extremely grateful, my lord.
হ্যাঁ, এইটা বইটা দিয়ে দিন আর এটা তো it will be here in the record, it will be sent to the registrar original site.
At number 31.
Your Lordship will recall, this is that matter where 6 wills where the same person had done 6 wills with 6 different properties. 2 of the other matters Your Lordship had appeared before as Mr. Shorashij was appearing. Your Lordship had asked the other 4 also to come in the non-contentious list. That is why these 4 are appearing, Your Lordship. I wish I could show Your Lordship the order that had been passed in the other 2, but I am told upon instruction that those orders have not yet been served. Order last order.
So it is appearing under the heading non-contentious. Yes. Under which order? Let me see that order by which it was directed to appear as non-contentious.
Lordship, the order of 23rd August 2024. 23rd August 2024. 27th? How much to 23rd? Actual bar to 23rd.
112.
112.
Okay, let me see that order.
May I hand over? Like we had done in the earlier 2 matters, Your Lordship, we had filed a list of dates.
Okay, just a minute.
How?
এটা তো হয়ে গেছে। ওকে, এটা 206 তো, এটা 112। হ্যাঁ, Robado. Yes. Yes, in this case, it was directed to appear under the heading non-contentious. Recordটা একটু দিন একবার। 112। The affidavits have been filed by the attesting witnesses in this matter. Yes, record and order. Learned advocate for the petitioner is present. This matter, in terms of the earlier order, was directed to appear as non-contentious. Heard learned advocate for the petitioner. Let this matter appear on 16/9/2025 for orders.
The other three matters also mentioned, same.
Let me see the earlier order. Directing the matter to be non-contentious, the earlier order. রিপোর্টটা ছিল এর আগের order. 19th August. In this case, was there any earlier order in 2024? Yes, 5th September.
5th September. 113, I believe your lordship has.
Acha, same order. Item number 32 also same order.
কি 114? 114. 5th September. Again, lordship will find.
Yes. Yes, record and order. Learned advocate for the petitioner is present. In terms of the earlier direction, the matter is appearing under the heading non-contentious. Our learned advocate, hearing is concluded. Let this matter appear on 17/9/2025 for orders. ওই দুটো হ্যাঁ আর এটা থার্ড এটা 17/9 31 and 32 16/9 and 33 17/9 Yes, item 34. Oh, same order as 33. To appear for orders on 17/9/2025. 30, 31 and 32 is same order. 16/9 appear করবে আর 33, 34 same order. 17/9 appear করবে. Yes, call the 12:30 fixed matter.
Your lordship, before taking up 12:30 matter,
Yes.
item number 35, the next matter.
Yes.
There was a direction on 20th of August 2025
Yes.
to the plaintiff to file opposition and thereafter to reply. I am the plaintiff have filed the affidavit in opposition. I am praying 2 weeks time to file my reply, your lordship.
Other side is not here.
But I appear for the receiver. Plaintiff is also here.
Item 35.
35.
Okay. This is GA15 is your application.
Yes, GA15 is my application. Plaintiff has filed, plaintiff in the suit has filed the opposition. I have received the same. I am praying.
And GA16 is your application.
That is
GA16 is my application.
I
I'm another intervener, madam.
I appear for the plaintiff in this matter, your lordship. In GA15, we've served the affidavit in opposition, but your lordship will keep it on record.
Yes,
your lordship.
record and order. Learned advocates for the parties are present. Let affidavit in opposition to GA15 filed by the plaintiff be kept with the record. Let affidavit in reply be filed on or before 17/9/2025.
Your lordship, 2 weeks time.
Okay. 24/9/2025. Let this matter appear on 24/10/2025.
Year 16, the next matter, if other sides wants to file any opposition, they may file.
Yes, call GS16.
Your Lordship will keep it on any day in the first week of November, Your Lordship.
I'm
After vacation any day.
আচ্ছা ওটাকে 24/10 না করে ওটাকে ইয়ে করে দিন কি না করো 3/11.
As your lordship.
Grateful.
Yes, call 36. Yes, 36, your application.
This is my application. This is, I'm another intervener.
Okay, item 36. Yes, affidavit in opposition.
Your Lordship, item 36 is their application for intervening in GA 15. So, Your Lordship, I do not have any opposition if they are allowed to.
They are trying to intervening in my application, but copy has not been served.
Okay, let copy of this application be served upon the parties. Affidavit, if any, be filed. Affidavit in opposition, if any, be filed on or before 24/9/2025. Reply, if any, by 31/10/2025. Let this matter appear on 3/11/2025. Same date.
Item number 37 and 38, both sides are present. Now, this matter is required to be adjourned, my lord.
Your Lordship, you have an innocuous prayer. Your Lordship, an appeal had been filed against the ad interim order that was granted to me, my lord. It has been set aside. Directions have been given to file.
Come tomorrow. If it cannot be taken up, come tomorrow.
My lord kindly keeps it after 2 weeks, only adjournment, because if it's been directed
Shall I
in
keep
the
it
order.
after vacation?
After
Yes,
vacation.
item 37 and 38. Theme order করবেন on the prayer of the learned advocates. The matter stands adjourned till 24/10/2025.
GA2 is returnable on 12th or day after tomorrow, my lord. That also may.
Both the applications may come together, 37 and 38.
Yes, I made it both the application on 24/10/2025.
I'm appealing for the petition in 30.
Okay, it will appear after vacation, 24/10, reopening date.
It's not 24/10.
Yes, you are for? Acha, item number 39.
Lordship, I'm appearing for the respondent number 5.
Item number 39, learned advocates. For the parties are present on the prayer of learned advocates, let this matter appear on 27/10/2025. The interim order stands extended for a period of 1 week after vacation. Yes, call the fixed matter, 12:30.
Wait, please, Your Lordship, my lord, today I am to give the reply
Yes.
to what Mr. Shomavo Ghosh and Mr. Rupak Ghosh, our Pentelio, has.
Because others have completed their submissions, you have to give the reply.
Yes, my lord.
And I shall fix a date to file the written notes of arguments.
I would try to finish the reply today, my lord. Your Lordship has given us enough indulgence. My lord, may I start with Mr. Shomavo Ghosh's submission first? My lord, Mr. Shomavo Ghosh, my lord, has tried to impress upon your lordship on 2 points. One is with regard to the conduct of Sujay Mukherjee. Major part of Mr. Shomavo Ghosh's submission has been to analyze the character of my client, which, my lord, in my humble submission, does not have any relation.
Case stands on the allegation of fraud. So only thing is this, as we know, that fraud vitiates justice. So your case can succeed if you can establish fraud.
I'm obliged.
That is the thing.
I'm obliged. So, my lord, Mr. Shomava Ghosh, my lord, he has tried to analyze the character of my client, trying to prejudice your lordship's mind with regard to as to what is the.
Yes.
What is the nature of person who has filed this application? And, my lord, if I have understood him correctly, his attempt has been to show that he is the person who is coming in between the settlement, between the defendant and the rest of the plaintiffs. My lord, your lordship, I would not repeat. Your lordship will recall what is the suit for? The suit is for the purpose of recovery possession of 2 godowns on, my lord, Portuguese Church Lane, which is a central part of Calcutta, two godowns are having 1700 square feet. There the plaintiffs are the tenants. By withdrawing the suit, what are the other partners doing? The other partners are giving their tenancy right to that of the defendant. So, my lord, in effect, the partnership firm is losing the right of tenancy over two godowns situated in the heart of the city, having an area of 1700 square feet. So, your lordship can very well appreciate as to what would be the consideration that would flow for a tenancy of this nature to be handed over to someone.
Yes, you see, now the
Yes.
question is, this court will not go into the merits of the decision.
Your lordship
What
would
is
not.
beneficial for the firm?
Your lordship would not.
Only the decision-making process has been fairly and reasonably followed or not, and whether fraud is played upon the court.
Your lordship would
These are the
kindly.
two things.
Yes, my lord, I'm deeply obliged. What my lord, Mr. Shomabo Ghosh has tried to impress upon your lordship is this: by withdrawing the suit, it is inuring to the benefit of the partnership firm, and the petitioner is standing in the way. My submission before my lord would be that this petitioner is coming in the way only for the purpose of seeing that the partnership firm is not in any way prejudiced. How is the partnership firm being prejudiced, my lord? It is my duty to bring it to your lordship's notice to see that this tenancy right that the partnership firm has is been given away to the defendant by withdrawing the suit. That's number one. It's a very lucrative place, and 1700 square feet is being given away without any consideration whatsoever. I put a question to myself: is it inuring to the benefit of the partnership firm? Am I, as a partner, not liable or not responsible to see that the partnership firm's assets are being retained properly? Or am I not having the duty to see that any partner who is doing activity which is going against the benefit of the firm be stopped? My lord, why am I trying to stop this? That is exactly the reason that I am trying to say. Now, my lord, with regard to having committed fraud on me, I have, my lord, shown your lordship many a time.
You have to show that you are not given any opportunity to set out your grievance.
I am going to show, my lord.
That is the thing.
Your lordship has
had you been given that opportunity, whether you could have submitted your grievance or not?
My lord, your lordship has seen, I have, my lord, submitted a written note. If your lordship kindly comes to page 16 of that written note. Yes, for the petition. Your lordship will be pleased to see paragraph 17. My lord, they have said that they have given notice to me of the various meetings that has been held, where they have fixed that this suit would be withdrawn. Your lordship, I have categorically stated the minutes, the date, the notice that was given, and the reason for the petitioner being absent. My lord, the first notice meeting is dated 30th of June 2023. The notice was dated 28th of June 2023. And by this letter dated 5th of July 2023, the petitioner was
in page 16. Yes.
Yes, my lord. Paragraph 17 onwards. Yes. First of all, this minutes, my lord, at page 17, I've stated that it has never been served upon the petitioner. It has not been disclosed. And my lord, the reason is the petitioner was informed that the notice was without agenda. The plaintiff number 9 had no authority to call a meeting as he was no more a partner. And my lord, the said letter was never replied to. I have stated this. Then, my lord, your lordship will kindly see the meeting of 16th of December 2023, never served upon the petitioner. All throughout, they have been claiming that they have been intimating me. In spite of that, I have not appeared. My lord, I have from evidence before your lordship annexed all documents to show that these minutes have not been served upon me at all. Then, my lord, your lordship will kindly come to the meeting dated 28th of December 2023.
Yes.
Again, my lord, no notice was served on the petitioner. The same would appear from the recording allegedly recorded in the minutes. They themselves have said, then, my lord, meeting dated, my lord, I am not troubling your lordship again with all these documents, but I have given details of all the documents as to where they appear, which how are they annexed, with which pleadings. My lord, again, the meeting dated 1st of February 2024. This is the meeting where they have finally, my lord.
2024.
Yes, my lord. Page 18, the last one.
Page 18.
No notice was served. So, my lord, from this, I have shown that repeatedly, whatever meetings were being held, it was all done behind my back. That is number one. That is, my lord, the specific reason for my saying that there has been fraud committed behind my back. Not only this, my lord, when this order was being passed, this order that was passed by my lord, where representation was made that all the plaintiffs are present, defendants are present. So, my lord, naturally, your lordship was made to believe that all the parties were present and they are wanting to get the suit to be withdrawn. So, naturally, there would not be any doubt in my lord's mind that there is nothing behind the screen. There, my lord, your lordship will kindly see, prior to the passing of this order has been passed on the 2nd of May 2025. That is at page 245 and 246 of the petition. I will trouble your lordship once more because, my lord, your lordship has very rightly observed that you just show me that fraud has been committed. This is how fraud has been committed on me. And not only this, my lord, misrepresentation before this honorable court. And this order has been acquired.
Yes, page 245.
Yes, my lord, that would be in volume 2 of the petition.
Yes.
Your lordship has got that, my lord. Very important would be the appearance. If your lordship kindly see Mr. Topon Seal, advocate, erstwhile advocate and record for the plaintiffs. My lord, I have demonstrated before my lord time and again that I have had communication with Chatterjee Seal. They were the erstwhile advocate on record. Someone on their behalf was there. I've intimated Chatterjee Seal much in advance that I am not wanting to withdraw. And my present advocate on record has also intimated Mr. Rupa Ghosh's client, the power of attorney holder, that I am not wanting to withdraw. I'll show it to your lordship that it has been addressed to premises which, as late as in 2016, he himself has said that he resides at Raja Dinendra Street. Now, my lord, he is saying that I have not received. I put a question to myself, where else do I send? He himself in his affidavit in opposition has stated that I reside at Raja Dinendra Street. And that is the address where that notice was issued by my present advocate on record.
Because the terms of settlement,
yes, my lord,
has been entered into between the plaintiffs other than your client.
Yes, my lord.
And by the power of attorney holder, probably.
Yes.
So this terms of settlement is signed by the power of attorney holder.
Yes, my lord. And also some of the party partners who are
defended from the defendant side. Yes, defendants executed.
No, one of them had
Even
and my lord,
Of the plaintiff and the defendants,
No, defendants were there, so no dispute. No, save and accept means what you see. has all the partners, that is the 9 partners who are appearing here, individually signed or simpliciter?
No.
Power of attorney holder signed on behalf of all the plaintiffs.
No, my lord.
Yes, let us see the position.
Yes, my lord, it is here. Your lordship, if your colleague comes to the affidavit and reply, page 60, I'll, my lord,
Affidavit in
demonstrate. There,
Yes, that is what I am in.
power of attorney holder along with all the other partners. My lord, I'll tell you.
All other partners means what? Other partners
Apart
means
from-
that means
Seven-
power of attorney holder is signing.
Power of attorney holder plus the other partners.
That is 9.
No, it is the name. Their name were there. They have not. Their names were there. Power of attorney holder have signed. And my lord, one very important factor which I was about to draw your lordship's attention was one partner who has has passed away by then. His name was also appearing.
Partner who has passed away means
Partner who had passed away by the time when the terms of settlement
retired or died.
passed away. His name is also appearing. That is also my case, my lord. So your lordship would appreciate what had happened. All their names are there, my lord. It's at page 60 of the affidavit in reply. My lord, the names of all the partners have been written.
Page 60?
60 of the affidavit in reply, filed by my client. So this is what is happening.
No. This is the factual aspect. So
Yes.
what is the position? Okay.
Position is, my lord.
Page 60.
Yes, my lord. Affidavit in reply to
Affidavit in reply by Sujoy Mukherjee.
Yes, my lord.
So affidavit in reply to whose opposition?
Somshankar. Somshankar is a power of attorney holder.
No. Affidavit in reply. Because you see, the other plaintiffs
Yes,
as well
yes,
as the
my lord.
defendant.
There are 2 affidavits in reply.
Yes.
Affidavit in reply to
opposition.
Somshankar.
No. This is with regard to Majid Khan.
No, arekta ache. There's another one. There's another one. Reply. Affidavit in reply to Somshankar. No.
What is on the record? These terms of settlement is not a fact. It has to be on the record.
Yes, it is.
So let me ascertain.
It is on my lord.
But it is before the court. It is a matter of record.
Am I not to answer my lord's query?
Yes.
No reply to reply to
I am
reply.
ascertaining the
No
position.
reply to reply to reply.
Okay, page
Don't make
50
out any case of reply to reply to reply. My lord, your lordship will kindly see.
My lord did not argue the point of previous address. He is arguing that now.
It is also on record.
No. In affidavit in reply, no new points can be incorporated. Okay. Only clarification and points of law. Now this is with regard to my question. Who signed this settlement agreement?
The power of attorney holder Somshankar, but your lordship will kindly see what has he written. Messrs. Asutosh Roy, Profullo Roy, and then he has written the names of all the partners apart from the petitioner and Somshankar Mukhopadhyay, constituted attorney.
Okay, signed terms of settlement.
Yes. The name of Pinaki Roy is also mentioned, my lord. Pinaki Roy by that time had passed away.
So have you stated in your petition that Pinaki Roy passed away?
No.
It's not there.
No.
No. Question is, if it is so, you see, any degree passed against or in favor of a dead person is a nullity.
I have not.
The problem that I'm facing is, after the entire argument is concluded,
Yes.
he is bringing
Suppose after the entire argument is concluded and it appears that one of the person was dead. So what happens to that?
Let them say whether the power of attorney was granted by all these people who are the plaintiffs.
Now the question is it so that one of the persons whose name is mentioned died at the time of passing?
Pinaki Roy, let them say that he is alive.
No question. All parties are bound to answer if this question is asked. All parties. because you see, name of a dead person is appearing in the record. If a decree is passed in favor or against a dead person, it is a destitute of legal effect. You see the legal implications.
My lord, subject to correction, my lord. Subject to correction, my lord. Perhaps the death of Pinaki Roy, my lord, I'm not saying it with a fact. My lord, perhaps the death of Pinaki Roy is already on record. My lord, I'll just indicate one thing to your lordship. Because Pinaki Roy has not been striked out from the array of parties. My
No,
lord,
when did he die? At the time of execution of this
He's died before, my lord. That death is on record. Perhaps there is one order that is recorded to that effect. My lord, I'll take that order out. If it is on record, my lord, I'll place it before your lordship. The fact that he has died, nobody is shying away from it. But the fact that, my lord, he is already in the array of parties, that is why this name has been incorporated. So these are the people who are parties to the suit. Pinaki Roy has not signed, my lord.
He is representing all these people. That is what he has represented. Pinaki Roy is a dead person and he's going to represent.
After this dead person, nobody was brought into the farm in his place and stayed.
No, others were there. Others were there.
No, suppose the partnership deed usually provides that after the death of one of the partners,
the heirs will come in.
Heirs were the
It's already there on record.
heirs are there.
So, my lord, there.
Anyway, you see, a power of attorney holder cannot proceed or execute any agreement or deed in favor on behalf of any person who is dead. This is the point of
The
law.
power fails. The power automatically fails. The power automatically.
Take instructions on this, but then what I understood is there was an original power of attorney. These people had given power of attorney. While executing the terms of settlement, he has introduced the power of attorney. He has received on behalf of all.
My lord, may I have my opportunity to reply? My lord, again, the
now
same
so
thing will come up.
Only one. Lord,
My lord,
may I just make one submission?
Power of attorney has signed on behalf of all the 10 partners.
All the 10 partners, out of which one by that time had passed away.
And including your client.
My client.
No, his name is mentioned by the power.
Yes. My client was not there.
Okay.
So that has been, my lord, one misrepresentation. Then, my lord, coming back to the order, page 245, if your lordship kindly sees. With respect, my lord, it is my endeavor to show that your lordship was not being given the proper facts. That was what led my lord to get the suit withdrawn. My lord, if your lordship kindly comes to the order once, I'm wanting recall of this order on various grounds. So the order is of 2nd May 2025. My lord, how the order reads.
Page
First,
60?
No, 245. The order, my lord.
245.
Volume 2 of the petition, page 245. Your lordship's query was as to how fraud has been committed has to be demonstrated. First of all, I've shown the minutes. Not a single minute has been served on me. And secondly, my lord, what has arisen? The cause of action for this application is the passing of this order, where, my lord, erstwhile advocate and record for the plaintiff was present. He has not said anything with regard to the letter given by my client that no, I don't want to withdraw. I don't want to withdraw the suit. Nothing has been said. There's no recording in the order. Then your lordship kindly sees learned advocate representing the plaintiff and the learned advocate representing the defendants are present. So, my lord, this gives an impression to this honorable court that all the parties who were there before my lord were present, which actually was not true, because much prior to that, I had intimated everyone that I am not going to appear along with the erstwhile advocate on record. I have a new set of advocate on record. And I've also specifically stated that I don't want to withdraw the suit. This was not brought before my lord. So automatically my lord felt that all the parties are ad item with regard to withdrawal of the suit. As a result, the consequential order was passed. Then, my lord, Mr. Seal, former advocate for the plaintiff, is also present. This is very important. Your lordship has recorded this, but nothing has been stated. Mr. Seal, by that time, was very much informed by my client that I'm not wanting to withdraw. I'm having a separate set of person. That was not brought into the notice of my lord. Then, my lord, the third paragraph, it is submitted by the learned advocate representing the plaintiffs. That is untrue. All the plaintiffs were not being represented. My client was not represented. And that, my lord, I've intimated that. I've shown it to your lordship, my lord. I would not like to repeat, my lord, over and over again. Your lordship has been very indulgent. My lord, page 209. Your lordship will kindly I'll just bring it to your lordship's notice. Page 209. In April 2025, I'm intimating the order has been passed on 2nd of May 2025. Yes. Page 209, my lord.
Yes.
209 of the petition, volume 2.
Yes.
Bharadwaj Law Chamber is the present advocate and record of my client.
Yes.
I'm intimating everyone. What am I saying, my lord? I'm saying that is at page 210. The last line, you are also requested not to take any step for withdrawal of the suit inasmuch as my above named client, that is the plaintiff number 10, is not inclined to withdraw the action but to proceed with the same. Repeatedly, it has been said that the power of attorney holder was not in any way, the power was not in any way revoked.
Law Chamber is engaged by you.
Yes, my lord, my present advocate.
That is on 28/4/2025.
Yes, much earlier than the passing of the order.
Did he file the power on your behalf?
Yes, he's appearing.
No. Prior, at the time of this incident.
At the time of this incident, my advocate on record. Yes. 30th of May.
30th of May.
Yes, my lord.
No, this order is 30th of May was a vacation.
No, he has filed the 28th of April.
First notice was served on
28th of no. When did you file the power?
The
On the 28th of April, I understand.
28th.
Yes, my lord. The day when it was the letter was sent. If your lordship kindly sees the contents of the letter.
28/4/2025.
Yes, my lord. The letter itself is explanatory.
Yes.
Please take note that I, the undersigned, have filed wakalatnama on behalf of my above named client on that in April.
This was received by me after the
No, not so. Please don't start all over again. The letter that it was received at the proper address, I'll prove it right now.
Whether the advocate engaged by you was acting within his authority or not.
Yes.
Unless he files wakalatnama, he cannot write these letters.
Right. He has said that I have filed wakalatnama on behalf of my client. 28th of April, and my lord, what had all throughout been argued that the power of attorney holder was not served. He did not receive address again.
It was never even received by me.
Mr. Ghosh clarify.
Not interrupted.
I'm clarifying now. No viewpoints.
Don't say such things.
You've not served on.
Don't say such things. I have got the proof here. That is exactly what I want to show to my lord. My lord, this is very unfair. My lord, your lordship will kindly come to page 209. My lord, your lordship will kindly not allow them to keep on having this running commentary.
Yes.
My lord, page 209. I know why they're so agitated. Now things will come out. My lord, item number 9, the person Shom Shankar Mukherjee. Which particular address has he been addressed to? 178 by A Raja Dinendra Street. They have been saying that they have not received this.
Now you see.
My lord, one thing.
This is your bone of contention. Yeah, that is the letter of advocate.
Return.
Now question is, your bone of contention is first of all, the letter of your learned advocate. That is dated 25th April 2025. Okay.
Yes, my lord.
Addressed to this
28th April.
This is 25th April. You see above page 208. Page 208.
First 208 is 25th
Yes, 208 was upon the advocate of the other plaintiffs.
Right.
Okay.
Yes, my lord.
So the proof that this letter was received. This letter was received.
Yes, they have not said that they have not. Okay. They are saying that power of attorney holder has not received.
Okay. Now, so far, this letter is concerned, there is no dispute as to this being received.
Yes.
Okay.
Not been received.
So, letter was received.
Not.
No.
Have you stated that in your
Item returned.
The power of attorney is not about the
Say
power of
25th
attorney holder.
This is the first letter,
Oh,
25th April 2025. Oh, I think this is by mail probably.
Yes, the email.
Oh, this is mail. No question of receiving.
The power of attorney holder.
That is to the advocate on record.
Yes,
Okay,
that is
that means-
exactly what I'm
Thereafter,
saying.
when the power of attorney holder,
Yes.
the person who has signed the,
Yes, yes,
the
yes.
terms,
Yes.
that letter is.
Now the question is,
That is not
the
what my
learned
lord-
advocate
my lord
who
is
has
asking.
filed
Yes.
and represented all the plaintiffs when this order was passed. I am putting one question
That
to.
person has given change by that time.
So this person,
He was
that means
he was
Falguni Jana.
representing.
Falguni Jana.
No, Falguni Jana is the present advocate on record.
Just a minute, you see.
That is
Now
the
the
reason why
question is-
may I make
question is,
submission
you see,
and may my
this is
learned
the
friend
letter-
talk up every moment.
This is the letter addressed. This is the letter addressed to the former advocates of all the plaintiffs.
Yes.
Okay. Now the question is whether this letter dated 25th April 2025 sent by one of the learned advocate to the other learned advocate. Okay. Was this is a mail. So no question of any this service report and all these things. So this mail has been received.
But by the time the terms of settlement was filed,
Yes.
this Chatterjee Shield was not my advocate.
No question of Chatterjee Seal, you see. Okay, this is sent to Chatterjee Shield.
Yes.
Okay.
The Chatterjee Shield was not my advocate on record
On-
when the terms of settlement was
on-
filed. My
on-
new advocate on record.
On 25th
Dr.
on 25th April you had sent this. Okay, this was the mail.
Yeah.
And whom else did you send?
If I may, let
Please.
Mr.
I am
Rupa
just
Ghosh
seeking
continue
clarification.
with the
Okay.
submission.
My lord, kindly now come to.
No. I am asking Mr.
Let
Ghosh.
them-
Let him clarify.
Let them do it.
It is his turn. Let him clarify.
I've never seen such things happening, my lord,
I
but
am
now
seeking a
everything is happening.
clarification. Let him clarify. Okay.
Everything is happening
So
now.
this is
You're
a
not
mail.
allowed.
No question of any.
I'm not misleading the court.
No,
Please
but this
have,
letter has not been served on me.
please have patience.
One by one, please.
You cannot quite use any phrase that comes to your mouth.
So far, this mail
But
is
used to making such submissions, please stop it.
So far
Misleading the court is a very big
I am
offense.
saying so with some responsibility.
Please don't. You don't have any responsibility then, it seems.
Now,
I have the
Yes,
liberty
now
of
so
showing
far-
it to my lord
Yes,
as to
yes, yes.
how it has been done.
yes, now turn your attention here. Now,
Yes,
so
my
far
lord.
page 208 is
Whatever,
concerned. There is no dispute because this is a mail.
yes, my lord.
Now else.
Yes, now with
Who
regard
else?
to 209,
Yes.
my
Who
lord,
have received and who have not received.
may I, my
Yes,
lord,
yes.
may I? My lord, 209, this is a letter which has been given to all the partners, including Shom Shankar Mukherjee. Where it has been given, now, my lord, their cases, they have not received it.
Okay, so it is your case that this letter was sent to, so far the document shows, was sent to all partners, including Somshankar Mukherjee.
Including Shom Shankar
Now,
Mukherjee.
who all have received and who all have not?
I'll tell, my lord, may I? Shom Shankar Mukherjee's specific cases that he has not received. But where have I sent it? Your lordship will kindly see 9 Shom Shankar Mukherjee 178 by A, Raja Dinendra Street, Kolkata. Your serial number 9, my lord.
Serial number 9, yes.
Yes. Your lordship has seen that address? Now your lordship will kindly come to affidavit in opposition of Shom Shankar Mukherjee.
No, but let him show the track report.
No, just
Let him.
Report.
one by one. Okay. Now this is with regard to Somshankar Mukherjee. As per the track report, it is not received.
Not
As
received.
my humble submission before my lord is that we have sent it to the address that admittedly he said that he is there in 2016. He says that he has not received.
In the other address
Right.
also.
There is another address, Olai Chandi Road, some other address. That is the plain address where it has been sent. They say that they have not received. Now, my lord, with regard
Yes. So
with
maybe that
regard
is
to the other partners.
Yes. Let us clarify that.
Yes, my lord, with regard to the other partners, if your lordship kindly comes to page 238. Everyone has received.
238, please.
Yes.
Let us see. 238. Okay. This is with regard to Rajeshwari Rai.
Yes, my lord. First, your lordship will kindly come. Let us start with my lord Chatterjee Seal and Company. Page 217. Let us start with Chatterjee. One by one, I'll come, my lord.
Oh, Chatterjee Shil is a male,
Yes,
probably. So no
217.
question of any track report.
They have that. They have received. That is what I want to show. Page 217. If your lordship kindly sees that they have received. Chatterjee seal was also represented before my lord.
Yes. Yes, this is
That they have received on 30th of April, 2025. Item delivered. Next, my lord, may I come to Probit
217.
Kumar Roy.
Okay.
Form also there, no? 219.
Monica Shet.
I'll come, my lord, one by one. Ashutosh Roy, the firm, page 219. I'll come to each and every one. Yes, yes. I just said 30th of
The
April.
records are before this court. Okay. Records are before this court.
Yeah.
Yes.
219.
Yes.
The firm has received on 1st of May 2025 at 3:1. 15:1 is in the afternoon.
Okay, that is to page 219 is?
Yes, the firm.
Okay, that is 15.
Yes, my lord. 15, 1st May, in the afternoon.
At 15:1.
Yes, my lord. And the order was passed the subsequent day, 2nd May.
Okay, okay. Order was passed on second. This is the farm. Okay.
Yes. Then, my lord, I'll show each and every one. I'll show. Jhumpa Chakraborty. Page 221.
Yes.
It's very easy to say that nothing has been given, nothing this, nothing that.
Page 221.
Page 221, Jhumpa Chakraborty, item delivered. Your lordship can see 1st of May 2025 at 5:05. Then, my lord, your lordship will kindly come, Pinaki Roy. Yes. Return, exactly, return.
Okay, this is page 221.
Yes.
Then page?
Yes, 224. Then Prosun Roy, 224.
Page.
It has returned. 224.
Okay, then page 224.
Yes.
That is
30th of April.
224. Just a minute. This is Prosun Rai.
Prosun Rai, 224.
Yes.
Then, my lord, Konika Seth, 218.
218.
Yes, my lord. Oh, it's a little, my lord, we have to come a little forward. 218. 30th April.
30th April.
And April is 31 days, isn't it? 30 days. Okay. 30 days. And they're all within Calcutta, Alambazar, this, that. It's not that miles away from Calcutta High Court. All within Calcutta. Then, my lord, your lordship will kindly come to Sharup Mukherjee. 234. Yes, returned. Let me see. It's there.
So for these five letters are concerned, it is admitted that they have received.
Yes.
5 letters.
Yes, yes. There are many others, my lord. From 10, 11, 19.
Anyway, you cannot conclude today. I will keep it tomorrow. Because how long will it take?
Well, if I'm given the opportunity of
reply, there is no new point, only clarification and points of law, nothing
only
more.
clarification and the judgment that my learned friend relied upon, I will just distinguish that.
Okay, just record an order. Learned advocates for the parties are present. Mr. Shwanendu Ghosh submits on reply to GA 11 of 2025, but could not conclude the submissions. Let this matter appear. আচ্ছা 16 তারিখে দেখুন তো 16 তারিখে 15 তারিখে তো 10টায় ফিক্সড আছে একটা আইটেম 10:30 দিনে 17 তারিখে 10:30 কিছু আছে Yes, I am keeping it on 17. Let this matter appear on 17/9/2025. Or timings kichu nahi. At 12:30 p.m.
I'll finish it, but I was wanting to finish it today itself.
And you come with the written notes of arguments, written notes of arguments to be filed on the said date
On the 7th?
by the parties.
আমাদের 16th অব্দি বলে দিচ্ছে।
What is going on internally? I have signed the
Mhm.
term, whether with 10 or 11.
Nobody is disputing your acts. Okay, your acts are not under challenge.
They're continuously showing these same arguments and taking time to delay the whole matter.
Okay, you give your written notes of arguments.
17th we will finish. That's the understanding.
No, 17th is
But
the
will
reply
they-
by Mr.
yes,
Ghosh.
I hope.
You give your written notes of arguments.
And my lord, the interim order may be extended for a further period of 1 week from 16th because it's
interim
expiring on
order
the 16th.
Stands extended for a period of 3 weeks or till 2 weeks.
Not from 16th, 1 week. That's why Leonard friend was saying that.
It's expiring on the 16th.
So, Leonard, 1 week from
Learned,
there.
the interim order stands extended for a period of 2 weeks or till further orders, whichever is earlier. এটা ঢুকি দিনের ভেতরে।
Your lordship will kindly excuse our raising of voice, my lord. We should.
Yes. If the emotions, okay.
Yes.
Emotions should be kept aside while arguing the matter.
Sometimes court craft also. My lord, may I only make my since Mr. Ghosh is there, my lord, in that Barik matter tomorrow, I may, your lordship has fixed it.
Oh, the other matter, Mr. Ghosh is appearing.
But I may be in some difficulty tomorrow. Can it be any other day? Monday, Tuesday, Wednesday, any
So
day?
if you want, I can keep it on the next week.
Next week,
Next
Mr. Ghosh is
Tuesday,
there.
usually your
Yes,
lordship.
chamber matters usually are taken.
Your lordship, kindly keep.
Anyway, I shall consider tomorrow.
Somebody will be there, and my lord,
Yes, send your junior, I shall adjourn it.
Mr. Dotto is also there. I'll
Mr.
intimate.
Doctor is there.
Once again, my lord, I tender my apology.
We can-
Especially fixed matter, item number 1 at 15. I am feeling on behalf of class.
Yes, you can continue because at 2:35 I have to rise. At 2:45 there is a division bench. Then thereafter I shall sit again at 3 p.m.
Then perhaps at 3 p.m. Single bench of
Double side is maximum 15 minutes. Anyway, you start, you see, let it. Yes, yes, yes. Anyway, witnesses are present.
Yes. So in cross-examination.
Okay, okay. Anyway, let him argue, thereafter I shall see.
For our recollection, Malata, I complete that. So for my contention in this matter is Malata, disproportionate distribution of share, exclusion of son from the share was not properly explained, and the aesthetics was suffering from Malata unsuccessful spinal cord surgery, and she was never fit thereafter. She used to consume huge medicine, and no medical expert was the witness in the will. Judicial was made just prior to the death of aesthetics, and the codicil was unregistered one, and the property which has been shown was not disclosed how he has obtained those property, and one proposal was come from the plaintiff side for settlement. Whenever my lord, they were asked to produce a medical document, they proposed for proposal of settlement, and scribe and witnesses are come. On the last occasion, I shown from the deposition of two witnesses. Today, my lord, I also show from the deposition of Ronobi Bosch, my lord, the date of the sitting was 14 August 2013.
Anyway, if there are suspicious circumstances, that suspicion has to be removed. That is the burden of the propounder. So, if you can show that there are suspicious circumstances, the burden is upon them to remove it.
I'll kindly say the deposition dated 14 August 2013. In the process examination, from question number 74, process examination starts from question 70.
Yes, 74.
74.
Yes.
What have prompted the aesthetics to make that codicil? Answer is, I do not know. When the will was registered one, but the codicil was unregistered document, why? I do not know. How was the relationship between the aesthetics and our relatives? Somebody had good relations, somebody did not keep good relations. Can you enlighten us why she was executed her relatives as the attesting witness in the will or codicil? I do not know the reason, but so far as I can remember, that she had said all her relatives how to do some work so that she can execute the will and codicil. It is learned that cooperation of the aesthetics was not successful one, and she was suffering since 1991. Then how could you presume that at the time of disposal of the will, she was mentally and physically fit? She was quite alert at that point of time. She had read the contents of the will and then put her signature on it. In a given situation, do you not think that medical experts should be one of the witnesses in the will or codicil? It is not necessary at all. When did aesthetics die? In the year 1990.
Okay, when the date of execution of the will?
1995.
90?
95.
95.
And so for the codicil is concerned, my lord, codicil was done February 1998, and the the testatics died April 1990. When did she make the codicil? In the year 1990? For your reminder that she died in the month of April 1998 and the codicil was made in the month of February 1998, then I can say that at the time of codicil she was seriously ill and she was not in a position to make the codicil. What I have seen was that her finger joint was swollen and that was the reason she had complications. She was quite alert otherwise. What was the cause of her death? Exactly, I do not know her cause of death. Most probably, it is written in the medical certificate or death certificate she died of heart failure. Your firm is the draftsman of the will as well as the codicil, then why the testatics has chosen both the witnesses from the said firm? Yes, because she had confidence on us. She had no confidence over her any relatives or friends. Is it correct? She might have certain persons she had chosen us because we are lawyers. Do you know the facts why the testatics that made her codicil at that time? It is learned that she was totally bedridden and she was under 24 hours nursing. Yes, I am aware of the fact. I say that she was not physically and mentally fit at the time of disposal of the will and codicil and beneficiary has predominated her. No, I do not agree. She was fully aware of the circumstances of for distribution of her property as in the terms of the will and codicil. Have you yourself checked up any medical certificate at that time while she was disposing of the will or codicil? No.
Disposing and deposing.
She was disposing of the will or codicil? No. In the probate case, the plaintiff has produced the medical certificate till 1993. Thereafter, no medical certificate was produced. Then after 1993, whether she was physically and mentally fit, at that point of time, she was quite normal. That means you did not check up any medical certificate. No. Kindly appreciate. Can you tell before the learned commissioner why in the will and codicil the same witnesses have been chosen? You must have confidence on us. Can you remember what is the reason behind making the codicil or what is the advantage in the codicil? I have not gone through the codicil. I am not supposed to know the contents of the codicil. He was the draftsman. He did not know the contents of the codicil. Then without going through the codicil, you are attesting and without going through the documents, you have signed it. My only duty is to see whether proper execution has been made. I am suggesting it to you that this will has been made and the codicil has been made by the beneficiary and it was under duress. No, that is not correct. Are you aware of the operation of Purna Boshu Mollik was not successful? Her lower part of the body was paralyzed.
So this
But
is
it
the
was not
this is by evidence of the attesting witness. Two attesting witnesses were examined.
Three attesting witnesses.
There were three attesting witnesses.
One is Kapen Boshu Mollik, another is Bishi Bose, and another is R.C. Bose.
So three.
And it was not concluded during the course of deposition. Mr. Bose, Ronovish Bose died.
Oh, this.
It was incomplete. That's why it was incomplete. Now your lordship kindly come to one thing. I draw your lordship's attention. That is, my lord, the witness of Joyce C. Bose. Kindly see question number 53.
তোপেন বসু মল্লিকের পুরোটা হয়ে গেছে তোপেন বসু মল্লিকের পুরোটা হয়ে গেছে
Kindly see question number 53.
Done Barco.
Yes.
Of Joyce C. Bose. How did you know them? That means how did you know the solicitors? They are my mother's solicitor and advocate.
Fine.
Page 50, question 53.
Yes. Question 53 of Joyce C. Bose. I will also put not wrongly. Joyce C. Bose, past sitting dated 11th December 2014.
আর একটা ডিপোজিশন এই দিন জয়শ্রী বসের
Joyce Ghosh.
জয়শ্রী was 53 হচ্ছে how did you know them? তাই তো?
11
কমিশনে হয়েছে 11ই ডিসেম্বর 2014। এই যে সামনের পাতাটা এরকম, দেখলেন সামনের পাতাটা এরকম হবে। রিপোর্ট থাকবে, রিপোর্টটার পর এটা তপেন বসু মল্লিক। না এটা না, না এটা না। এটা না। না, এটা আপনাদের। এটা রণবীর পাত্র। রণবীর। হ্যাঁ এটা দেখুন। হুম, হুম। আমাকে একটু আমারটা দেখ।
Question number?
53. Can you say how did you know them? How did you know?
Question 54.
53.
53.
How did you know them? They are my mother's solicitor and advocates. Also, right now, they are my whole family.
53. Okay, they are my mother's solicitors. Also, right now, my whole family.
Whole family. That means the intimacy between the solicitor and the beneficiaries are very much.
No, question is whether they are straight away the relationship with the beneficiary or through her mother. That is the thing.
No, how did you know them? They are my mother's solicitor and
Yes,
advocate.
that means.
And also right now, they are my whole family.
That means they are treated as a part of the family.
No, my lord,
Anyway,
this is
sometimes
perhaps, my lord, what has been stated is, my lord, my whole family, in the sense they are solicitor and advocates of my whole family.
No, that is.
Because, my lord, otherwise it won't make any sense.
Anyway, that means
because solicitors advocates cannot be their
these
family.
solicitors and advocates used to look after the legal matters of
entire family
of their mother. So this is
now they are
no now, but you see, in the present, if he comes to the present, there is a past how these persons came to be acquainted. So these lawyers used to do the legal matters of the mother.
And now my my whole family. They are.
But that sentence cannot be read in isolation, my lord. It has to be read with the, my lord, previous sentence.
Yes, if there is good relations, they are also treated as family. Okay.
My lord, actually, what happened was, my lord, it was, my lord, the entire family had, my lord, deposed, my lord, trust and faith.
Now,
on
how long has your family been associated? For 30 years. So this was executed in 1998. 95.
95 will was made.
So 65. So 30 years means 65.
And 98, just prior to the death, codicil was done. And codicil was unregistered one. I also pointed out that before whom before the notary, the notary public, it was done, and that notary public was not called for any.
So these same witnesses are the witness in the codicil also.
Yes, fair witness. Common both brothers, Mr. Bose brothers are the common witnesses in both the codicil and as well as the will.
So this one was registered, original will was registered.
Was registered by codicil, some property has been changed.
Okay. So had the property not been changed, to whom it would have been devolved? The property mentioned in the codicil?
Most of the property has been given to
No, that's a different issue. In codicil, how much is the change?
codicil, my lord, kindly.
How many properties are there which is brought under the codicil?
আমি খুঁজে পাচ্ছি না। বিলটা আছে।
Anyway, you come look into that on the next day.
Codicil, my lord, kindly see, I, Srimati Aruna Basu Mollik, wife of Sarojendra Chandra Basu Mollik, residing at 4A Short Street, Calcutta, hereby passes this codicil to my last will and testament dated 17th April 1995, registered with the Register of Assurance, Kolkata on 27th July 1995, in book number such and such, deed number such and such, for the year 1995. Notwithstanding anything to the contrary content in the said last will testament, I direct the first floor of the premises number 4A Short Street shall devolve upon my grandson Prasad Basu Mollik, son of Pradeep Basu Mollik, in the event he is so nominated by my three daughters, namely Joyasri, Monjusri, and Devusri.
So earlier it was upon whom?
Now they are getting.
Earlier, this condition was not there.
No, earlier it was, what was the condition?
It was without independent condition. Well, this condition
Absolutely upon
the
beneficiary.
beneficiary.
But thereafter it was modified.
Modified, and it is dependent upon the all the all the three daughters. That means his fate will be dependent upon all the three aunts. That means father, sister.
So earlier the beneficiary was this grandson. Earlier.
I further direct that in addition to my youngest daughter, Devosri, my father, Prashantu Kumar Mistru, shall be entitled to reside and occupy the portion he is now occupying on the first floor of premises number 4A Short Street, Calcutta, during his natural life. I further direct and immediately after my demise, the letting out of the lawn to the south of the existing building at 4 Short Street and the ground floor thereof for holding marriage and other ceremonies shall be discontinued. Further, notwithstanding anything contained in my said will, I direct that any money received by me during my lifetime from tenant of premises number 2, Jawaharlal Nehru Road, Calcutta, deposited in any bank account shall be made over to my executives, Joyasri Ghosh, who alone shall be entitled thereto as all future rent issued and profits from the said premises. That means the executives is the sole beneficiary in this point. I have also 2 flats with Lake Town in the building constructed on the land. I have sold being premises number 219.
Anyway, continue on the next day. You record an order. Mr. Pal, learned advocate for the defendant, submits but could not conclude the submissions. Let this matter appear on 16/9/2025. যে 16 তারিখে দেখুন তো দুটোর সময় ফিক্স ম্যাটার আছে। ওকে 16/9 17 তারিখে হ্যাঁ 2টোর সময় একটা ম্যাটার আর 18 তারিখে পনেরো তারিখে নেই বোধহয় ওকে আই এম কিপিং ইট অন 15
Oh, 15 ballot due to the farewell of Honorable Chief Justice ballot.
okay 22/9/2025
Malad, the 15th, I believe. Malad,
I'm keeping it on 22
Oh, 22.
9/2025 at 2 p.m. অরিজিনাল সাইড যেটা উইটনেস কি প্রেজেন্ট আছে? Huh? And both sides advocate are present?
Yes, my lord, we are present.
Yes, I'll take it up after 10 minutes. The appellate side matters. What, original side?
No.
Just wait for 10 minutes.
My witness was being cross-examined.
No, no, ওই করা আমি আরে মাইকটা তো আরে এটা আমার ডায়েরি আমার লাগবে এটা 10 মিনিট এরকম করে কেটে যাবে What is your name, sir?
চিরঞ্জিত মিশ্র।
চিরঞ্জিত মিশ্র। আইডি কার্ড আছে আপনার কাছে? Yes. Mr. Mishra, who has authorized you to depose in this matter on behalf of the defendant number 3?
Our regional head has appointed.
Our regional head?
Regional head, Kolkata Metro 2 region, Bank of Baroda, Kolkata.
It is suggested that you were not around when the disputes in the instant matter arose. Is it correct?
Yeah, correct.
You will say yes, say yes. Yes, correct.
Yes, correct.
How did you derive knowledge of the instant case, the dispute in the instant case?
I don't have any personal knowledge on it.
Yes. Have you gone through the records of the proceeding?
Yeah, yes, the document that was there, I have gone through once.
What records gone through?
Gone through once.
Go slow. What records did you peruse to obtain the knowledge of the dispute?
No, I think the case file that was there, that only I have gone through.
Can you tell the name of the plaintiffs in the suit?
Plaintiff, as in who has filed the case?
Yes.
Not exactly, because I don't know them personally.
You don't know even the name of the plaintiffs?
Somor Saha and some.
Somor Saha.
I don't have the knowledge of this thing.
I do not have any personal knowledge about them. Any personal knowledge. Are you familiar with the signatures of plaintiff number 1 or plaintiff number 2?
No.
What is the procedure for opening a joint bank account?
An application form signed by both the applicant and a signature card is taken.
Is it mandatory for the applicants to put their signature on the specimen signature card while opening the account?
Yes, if it is like their signature has to be uploaded for operation of the account.
Go slow, sir. Go slow, sir.
For operating an account, the signature which is required either or survivor or maybe jointly. So those signatures has to be there on the signature card.
The signature card. What would be the consequences if one of the joint holder has not put their signature on the specimen signature card or any other document?
Then his signature, no check or nothing should be passed on his signature, if that is there.
Would the
If the signature is not available, no instrument should be passed based on that signature later on.
would the bank still be able to open the joint account in the absence of signature of one of the account holder?
Say exact 1995, I am not aware. But as on date, yes, for a joint account, if two parties are there, both should sign.
এই exhibits আছে exhibit 9
তো কোনো লাভ নেই exhibit কথা বললো মোবাইল থাকলে সুইচ অফ করে দিন
এইরকম ডকুমেন্ট আছে দেখো এটা লেখা থাকে না এটা আমরা টেন্ডার করেছি অরিজিনাল হবে এখানে
Anyway, let us stop here for today. I'm fixing another date.
You step down.
Record an order. Learned advocate for the petitioners, learned advocate for the parties are present. DW3 is present in court. DW3 is further cross-examined. As the cross-examination could not be concluded, let this matter appear on next date. 17.
My lord, on 17 we have some difficulty. Can you be either on 16th or 18th?
22.
Okay. 18/9/2025.
18th court.
But if it can appear on a Friday or a Monday, subject to your lordship.
18th is Friday.
Friday.
Okay, then 22/9/2025.
22. Yes. But at 2 p.m.
Yes, 22/9/2025 at 2 p.m. Yes, appellate set matters.
Not last second of this month, came before the lordship on matter item number 1 the list. The date before the trial court is fixed on 15th. That is on Monday. Lordship will sit challenging the quantum of the maintenance amount. London magistrate awarded the same without considering.
Oh, the matter is to appear before the trial court for what purpose? Trial of the case.
Execution of city. Lordship, not considered the assets and liabilities, affidavit of assets and liabilities. Because thereof, I challenge the order in full. Today it is appearing as item number 148.
Yes, item 148. Let this matter. Item 148 लिखे नहीं तो. Let this matter appear as a specially fixed matter on Friday. On Friday. On 12/9/2025. Yes. Item 31. Okay, if it is not taken up, tomorrow I shall take it up. Yes, yes. You mention, I'll take it up.
Item number 47, my lord. In this case, my lord, there are 4 accused persons. Against a single order, 2 different revisional applications have been preferred.
Yes.
One is being heard by courtroom number 7. It was listed as item number 9 today in the morning. The other one is 47 before your lordship. So either your lordship hears out both the applications together tomorrow, or
you see, I can hear what is assigned to me. I cannot hear something else.
In that case, your lordship will kindly release the matter for item number 47 so that can be placed before the other bench where the other revisional application is pending.
No. What is the difficulty if the 2 benches takes up these matters?
It's the same order.
May I say this? But I was appearing in that matter, led by the public prosecutor.
Yes.
So that matter.
You are for the state.
Yes.
Yes.
That matter. May I say this, my lord? This is a matter wherein the present petitioners have filed an application of 319 post-argument stage. This is a 302 application. This case relates to 302. Post-argument, they have filed a 390. There are 4 accused persons. 2 set of revisional applications have been filed because the order challenging the.
What do you suggest? The matter be taken up by this bench?
May I say this?
Yes.
The other bench, presided by Justice Parthasarathi Chatterjee, this matter has been taken up. Arguments have been concluded. Day after tomorrow is fixed for 4 orders. Today, now they are mentioning before your lordship that let the matter be released. But the notice which they have sent us, that they say that they wish to withdraw. Now they are saying that the matter be released and placed it before place it before the other coordinate bench, which has already heard the matter because
the matter fixed before the trial court.
Well, the trial court, the next date is fixed on 20 for judgment.
29th of
September.
Because this matter has already been heard.
Very well. I have not been heard, my lord. I want to be heard over there as well.
So
whichever court decides it, let me be heard. I am also an accused.
Let this matter be placed before that bench because it has been heard out already.
Yes, record an order.
47.
47. It is submitted by the learned advocates. for the parties that the similar matter, the self-same matter with regard to another co-accused person is heard by another coordinate bench, which has reserved this matter for orders. In the facts and circumstances, the bench, and it is reserved for orders. In the facts and circumstances, the matter stands released. The matter may be placed before the bench hearing on the self-same issue.
Obliged, madam. Obliged.
Okay.
Let our appearance be recorded, my lord, because
Yes.
he's
Give your
mentioning
appearance.
He's mentioning upon notice.
My lord.
Joydeep Biswas. ঠিক আছে? Joydeep Biswas. Obliged, my lord. Obliged.
Number 1. May it please, Your Lordship.
Yes.
You know the you can call them.
Yes, let us consider the order passed by the learned magistrate.
Lordship. Lordship, before
You are
that,
challenging that order.
I've changed the order, but Lordship may just kindly recall, Lordship wanted to know why the police has filed a final report, not charge sheeted. So what was the finding of the police? What was
Yes, thereafter, it was objected to, and the learned magistrate directed re-investigation.
That order was non-speaking order.
Okay, let us see the order. The order which is under challenge.
Under challenge is the second. This is the second when the Honorable High Court has reverted back the matter.
No,
Relegated the matter
You are
to be
challenging which order? This one.
This one, 3rd May.
Okay.
3rd May 2025. This order consists of 2 parts. 253 करो. नहीं बंद करो. अच्छा. मुझे तो बोलो कैसा है. रीडिंग कंप्लीट पेज 183 में था. रीडिंग कंप्लीट. इसको रखो फोड़ कर दो. रीडिंग कंप्लीट कर लो पेज 183. दूसरा बोलेगा ना.
Now you see, the learned magistrate has given the reasons for directing the reinvestigation.
Correct.
So,
but I have
not that an unreasoned order.
No, it's not a question. No,
So,
first, just
no,
give
what
it
is
to
the
me.
error in this order?
Error, I'll show you.
Yes.
Lordship, the Lordship might be like the first order passed by the learned magistrate was non-speaking.
Yes.
Which was challenged by the petitioner in the High Court.
Yes.
The Honorable High Court found that it is a non-speaking order. So the matter was again remanded back to the trial court for reconsideration.
Yes.
Now, when it was remanded back, there was an order passed by the Honorable High Court that fresh hearing be given, opportunity of hearing the parties concerned.
Where is that order? Which page?
Lordship, the order is on page 736.
Page 736.
This will find, Lordship, in volume 5.
Yes, page 736. Yes. The relevant portion of the order?
The relevant portion of the order. Page 742.
742.
Last paragraph,
Yes.
9.
Where is that opportunity that you will be?
9. Last line. The trial court shall hear the Narazi petition afresh by giving an opportunity of hearing to the parties concerned and dispose of the petition in accordance with law by passing a rescission order within period of 2 months from the date of order.
So you are aggrieved by this order?
This I was aggrieved for, because the learned magistrate has refused to hear me. This is number 1. Now, number 2, my case is based on 4 points. First point is that the de facto complainant in this case used lodged the FIR, which was registered on 22nd October 2020. Lordship, I was showing you the date. May Lordship place the case?
No, that is one ground. The other is?
This is the one ground that he has no locus.
Yes.
That the police in his final report has observed and came to the finding that de facto has no locus. That is not considered in the order sheet. Which Lordship was saying that there was a reason given by the learned magistrate. Nowhere you will find from the order.
Yes, record an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. Peruse the materials on record. The petitioner is aggrieved by the order passed by learned Chief Judicial Magistrate Howrah on 3/5/2025 in GR 4678 of 2020. Learned advocate for the petitioner submits that the order passed by the learned magistrate was without giving opportunity of hearing to the petitioner, which is contrary to the order passed by this court in CRR 3721 of 2021. Upon perusing the order passed in CRR 3721 of 2022, it appears that the Honorable Coordinate Bench of this court directed the trial court to hear the Naraji petition afresh by giving an opportunity of hearing to the parties concerned, and this to hear the Naraji petition afresh by giving an opportunity of hearing to the parties concerned and dispose of the petition in accordance with law by passing a reasoned order within a period of 2 months from the date of this order. In accordance with this order, it was necessary to hear the accused person, which the learned magistrate has refused to do. Learned advocate further submits that necessary materials on record and necessary observation made by the IO was not considered while directing the investigation. Stop. It further appears from the record that arbitration proceedings and other civil proceedings
going on
and were also pending between the parties. Upon hearing the learned advocates and considering the facts of this case, this court is of the view that this application should be admitted. Thus, I admit this application.
There is one more order which has not been disclosed, my lord.
No, he is challenging this order.
There is one more clarification order.
Okay, let this matter be admitted. You come with this necessary orders. This matter be admitted. Let notice be issued upon the opposite parties within 1 week, and affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Pending hearing of this application, there shall be a stay of the order dated 3/5/2025.
Obliged, Lordship.
Passed by learned Chief Judicial Magistrate Howrah in GR 4678 of 2020.
Grateful, Lordship.
Copy has not been served to us.
I will serve. That is the direction now.
Then let me do one thing. As learned advocate,
He's
the
present
de facto
there?
complainant is present. Service upon the de facto complainant is dispensed with. Let a copy of this application
Lordship. 5
be
volumes.
given to the learned advocate.
Within this week, I'll give it.
Who is appearing
Within
today?
Friday. After 1 week.
No. By this week.
No, I'll serve within Friday.
Yes, Friday means
Yes,
this week.
yes. Definitely. Grateful.
And one more. Is there any?
Yes.
Is there any direction for filing of affidavit in office?
No. Criminal revision affidavits are not required. Whatever records you want to produce, you produce it. For a period of 2 weeks after vacation.
My lord, I am challenging, my lord, the order, my lord. My lord, I am placing the certified copy first before your lordship. It is also annexed.
Yes.
My lord kindly takes the certified copy, then it is there, my lord. But otherwise, my lord can always have a look at the order impugned, which happens to be at page 41.
Yes.
My lord, complaint case, my lord, under 270. My lord, I am just giving, my lord, this is a most very formal order, my lord. But why I am saying, my lord, because the glory of judgments are there, my lord, that the learned magistrate should come to form an opinion, prima facie, for issuance of process. Starting from that, my lord, what has happened is this property, the complainant happens to be the director of a borrower company. Petitioner before my lord is an employee of State Bank of India. An order was passed under the SARFAESI Act.
So where is that order?
I'm coming, my lord. Lordship will kindly take up.
Yes.
First, my lord will kindly take up page 42. My lord, I'll not take more than 3 minutes, my lord, as far as factual matter. My lord, this is the order, my lord.
Yes.
Lordship, you have seen it under section 14.
Yes.
Lordship will kindly see Kalyaneshwari Metal Private Limited and, my lord, the land. On the next column, my lord, if my lord kindly allows me to description of the secured asset, my lord, it is in Kulti.
Order was disclosed before in the complaint
My
petition.
lord, it's everything suppressed and, my lord, complaint made against a dead person. A person who is dead and gone in 2010, complainant alleged that she came. She resurrected from her graves and she came and she threatened. Be that as it may, perfect case of suppression of material facts. Now, my lord, this is, my lord, the order under section 14. Now, my lord, this order was communicated. On next page, Lordship will kindly come.
Yes.
30th of September 2024, this was communicated to the subdivisional magistrate. Lordship has got. Now, my lord, will kindly come to the next page. Page 44 is the possession, letter of possession where I had accepted possession. My lord will kindly mark the name. Bottom, my lord, it is the petitioner whose signature is there. And, my lord, just before that, my lord will kindly see possession of the above said property is handed over on this 20. My lord, have got it, my lord?
Yes, yes, yes.
On 29/1/2025. My lord will kindly mark this date to Sri Shambhu Kumar Singh. Shambhu Kumar Singh happens to be the petitioner before my lord.
9/1/2025.
Complaint lodged after 3 months. In the month of March. I'm coming to that later, my lord. Now, my lord will kindly see 29/1/2025 is the date when I received possession on behalf of the bank, Sri Shambhu Kumar Singh, who happens to be the chief manager and authorized officer of State Bank of India. Now, my lord, this is the petitioner and the land has been given. The description is in the description of the property, which will match with the petition of complaint description. Now, Lordship will kindly see, then there is the Panchanama of the movable properties at page 45 and 46 happens to be, my lord, whatever immovable properties we could lay our hands on. Now, Lordship will kindly come to the complaint, which is at page 49. Page 49, P7. Lordship has got. Now, as my lord has already noted that this possession was given to me in the month of January. Now, my lord, what happens is this complaint has been lodged on 29th of March 2025 before the concerned Commissioner of Police. Now, my lord, here, my lord will kindly see, he says he is one of the directors of the borrower company, so he is supposed to know everything. I, Arman Ali, son of Shamsuddin, of 35 so-and-so, situated at Nimtola Mauja Rampur at Kulti, Paschim Bardhaman, do beg to lodge this complaint to the effect that I have been running my business under the name and style of Kalyaneshwari Metal Private Limited at Mauja Rampur, PS Kulti, district Paschim Bardhaman.
Now, who is the accused in this case?
My lord, the bank manager.
Present bank manager?
Yes, my lord, he is the petitioner before my lord who had taken possession.
Okay.
My lord will kindly come to the petition of complaint.
Shomir Kumar Chatterjee.
My lord will kindly come.
Yes.
I'm placing my lord. My lord will kindly come to the, my lord may come to the certified copy. It's there, my lord. Or my lord.
All bank officers.
Yes, my lord. No, some are bank officers. One is a dead person. My lord has gone laid my lord's hands on the certified copy, the petition of complaint. My lord will kindly see. The first person is Shambhu Singh, whose name appears as the person who took possession. Then, my lord, the second person is the security agency who is in possession. Now we have taken possession. He has totally made a false complaint that we ran away. We are in possession. This is a security person. Then, my lord, Jeet Chatterjee is also a security person. Now, Smita Chatterjee, whose names comes, who is the wife of one of the employees, from where he could lay his hand on that name, we are unable to understand. But this lady is dead and gone. On 16/6/2010, my lord will kindly see Sushmita Chatterjee. Then look at page 48. Page 48 of my lord's brief.
48.
Lordship, kindly see page 48.
Yes, 48.
My lord will kindly see Sushmita Chatterjee, death certificate.
Somita Chatterjee.
Somita Chatterjee, I stand corrected. On 90, and she died. My lord, the correct typed copy is at 48A. 19/6/2010. And this person has been,
police information was lost. Thereafter, this complaint petition is
my
filed.
lord, possession taken in the month of January.
Yes.
First complaint lodged to the commissioner stating all these false things, saying this lady who is dead and gone and Sambhu Singh, who is the petitioner, and the manager had come and tried to oust him and robbed 50,000. And then when no cognizance was taken by the police, he went and filed this complaint under section 200 of the old act. And without verifying, without sending it for any verification, the learned magistrate passed the impugned order issuing process. Now, my lord, if my lord kindly allows me to place the petition itself, my lord will kindly find what statements he have made, my lord. If my lord kindly comes to the certified copy of the petition of complaint. Lordship has got it.
Yes, yes.
My lord will kindly allow me to see he himself is saying that he is one of the directors.
Yes.
Now, my lord, the sections which he has alleged is 329, 324, 5, 303, 351 and 3 of 5. Now, my lord will kindly see the allegations which have been made by him. My lord, now because the BNSS has come, my lord, it was all we had learnt all these sections by heart, but now we have to see the book.
These old sections?
Old sections are the same, my lord, as we have stated, my lord. Now, my lord will kindly see what is his statement. He says that he is the director. Then, my lord will kindly come to the next page, which is the internal page 3.
Yes.
The allegations at paragraph 5. That your complainant did not pay any extra attention to those persons. Who are those persons, my lord? At paragraph 4. That for the last few months, several persons had been invading the business premises of your complainant. There's a paragraph 4. Under the instructions of accused number 1 to 6. Now, my lord, we have already taken possession. Few months means in the month of March, he is taken. So, this is a total false statement. And they have been extending criminal intimidation for closing down the said business of so-and-so under the name and style of Kalyaneshwari Metal Private Limited. Then he says that your complainant did not pay any extra attention to those persons who claims themselves to be the authorized persons of accused numbers 1 to 6 with the hope to believe that with passage of time, their confusion regarding anything about the business could be resolved. That on 28/1/2025. Now, my lord, 29th, I get the possession. If my lord kindly allows me once again to show, on 29/1/2025, I get the possession at page 44.
Yes.
And he alleges that on 28/1/2025 at 3 p.m., the accused number 1 to 6, along with 5 persons, had caused criminal trespass into the said business premises of your complainant and had ransacked.
Earlier police complaint was before the magistrate.
No, my lord, before the commissioner.
No. Earlier police complaint, no.
He says.
No. While taking cognizance of this case.
Yes, my lord.
The learned magistrate must have gone through the earlier complaint.
Yes, my lord, that complaint, if my lord kindly takes up internal page 4 of the petition of complaint at paragraph 9. Paragraph 9 of that petition, my lord. My lord has got.
Is annexure, that is?
That, my lord, certified copy. If my lord wants to see the annexure, yes. If my lord kindly comes to P1, page 34, petition of complaint. P1, page 34. Certified copy also it is.
This is the complaint petition.
Yes, my lord. Here he has alleged in page 36 that on 28/1/2025, the petitioner along with Lordship will kindly come to page 36.
Just a minute. You see, last page, this is also certified.
Yes, my lord. That is certified copy. We have annexed the petition
of the police information.
Yes, my lord. Everything is there forming part of the certified copy, but just for my lord's ready reference, I had paginated it also. Now, my lord, this is the police complaint made to the commissioner on 29/2025, which was sent by post and which he refers to
So your
Now, my lord, he's
intention is without
no,
causing
my lord.
an inquiry?
One more point, my lord. He may just as an assisting my lord's officer, my lord, in page 4 in of the petition of complaint, he refers to a complaint on 28/1/2025 to the local police station, which is neither here nor there. But what he annexed to his petition of complaint, the entire certified copy we got, was his complaint before
So on 29/3.
Lordship, that is 3 months after.
Yes.
Now, my lord, certain judgments are there, my lord. If my lord wants, I
Yes,
may
the
cite.
court noted. Learned advocate for the petitioner is present. Her learned advocate for the petitioner. Peruse the materials on record. This application is directed for quashing the complaint dated complaint case being
My lord, it is
351 of 2025, now pending before the Court of Learned Judicial Magistrate, 6th Court, Paschim Bardhaman, Asansol. It is the contention of the petitioner that the complaint was lodged by the complainant by suppressing the material facts. It is further contended, submitted that the petitioner, along with, you have come for how many petitioner accused?
my lord, only one, my lord.
Okay, the petitioner, along with other co-accused persons, took steps to comply the order passed by the Learned District Magistrate, Paschim Bardhaman, in the case of, yes,
my lord, may I crave my lord
District Magistrate and Collector Paschim Bardhaman, in case number SARF within stroke DM stroke 34 of 2017. It will appear from the said order and the materials on record that position was taken with regard to the property of the de facto complainant in compliance of the said order. It will further appear from the complaint filed before the learned magistrate and the complaint lodged before the police authority that there is some suppression of material facts and there is some inconsistencies. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings in complaint case number 351 of 2025, now pending before the Court of Learned Judicial Magistrate, 6th Court, Paschim Bardhaman at Asansol, for a period of 3 weeks after vacation.
I'm grateful. My lord, one more innocuous prayer, my lord. My lord, with my lord's leave, my lord, may I incorporate State of West Bengal, my lord, typographical error, my lord, my advocate on record.
The State of West Bengal be made a party and notice be issued.
I'm grateful. My lord will record the leave is granted, my lord, to
leave is granted to
petitioner to
complete State of West Bengal as a party,
my lord,
and to issue the notice.
I'm grateful, my lord. I'm indebted, my lord. I'm grateful, my lord's leave.
Number 3. Number 4. Number 4, I am for the petition. But I have come up for quashing of a proceeding. It's a charge sheet quashing, millet. But the petitioner before your lordship, petitioner number 1 is a septuagenarian lady, and petitioner number 2 is the daughter of that petitioner number 1. But they owned a property at 302 Diamond Harbour Road. The complainant happens to be friend as well as partner of one of the business of the husband of the petitioner number 1. There were certain issues regarding the business. The complainant attempted to grab a portion of a ground floor of the property, for which this complainant had lodged a complaint with the concerned police station, which your lordship will find at page 93. This is the complaint. Thus petitioner number 1 had lodged against the complainant with an allegation that he is trying to capture a portion of the property. No steps were taken.
No.
So,
were these particular petitioners mentioned in this complaint? Names?
Yes, my lordship would kindly come to the signature part.
No. You see, page 93 is the complaint. On the basis of this complaint, case was instituted or 156.3?
No, Millet. This is a complaint lodged by the petitioner number 1 against the complainant Kashinath Bhattacharya.
Yes.
That he is trying to capture a portion of my ground floor property.
Okay, now this case is instituted on the basis of whose complaint?
I'm coming to this. Now, lordship would kindly come to the next page, page 94. Since no steps was taken, I had preferred a 144. There was a specific order was passed, a restraining order against the complainant herein. Now, in spite of that, there was a further attempt for which I had filed a civil suit. I had got an injunction order, which your lordship will find at page 112.
Yes.
My lord, would kindly see the ordering portion.
No, it is against which person? The
My lord,
defendant?
yes, my lord, the plaint I have annexed. Your lordship will find the plaint at page 99. The cause title, your lordship will find that the complainant. Name of the complainant as defendant.
When was this complaint instituted? Prior to the suit or subsequent to
No,
the suit?
Millet. What they did, initially they filed a 156.3 application in the month of January.
Yes.
Police kept it pending. No inquiry report was given. The moment I have communicated this injunction order, police gave a report, and based on that, the case has been registered on 18th of April subsequent to this order. And Millet, ironically, the case is of theft where they could not produce a single scrap.
Charge sheet is submitted.
My lord. I have come up against the charge sheet, Millet.
Let us see, have you annexed that?
Yes, Millet, I have annexed. The charge sheet is at page 152, Millet. (152) is the formal part. Lordship would kindly see column number 10, details of the properties seized nil. They are alleging the allegation of theft or of committing or ransacking their property or their possession. No document has been produced in support of their contention that the articles which were stored over there or their possession has been seized. I have been foisted with a charge of trespass in respect of a property which belongs to me. There are other several proceedings, Millet, pending against this person.
Accused persons, how many there are?
There are 2 accused persons, Millet.
That is?
Kindly see column number 10A, number of accused persons charge sheeted 2.
10A. Yes.
Petitioner number 1 is the mother, petitioner number 2 is the daughter.
2.
Just to circumvent the civil proceeding and the order of injunction passed therein, this criminal case has been foisted based on a complaint which was lodged earlier. And during the investigation, Millet, no steps have been taken to verify the truth. And in fact, the investigating agency himself opined that during the investigation, there is no scope of getting the alleged medicine which has been stolen therefrom or any document pertaining to that to be seized. Two lady, one aged about 68, 69 years. Another is a professor by person.
This is 1,12,000.
That is
valuable medicines.
That is the allegation. Firstly, Millet, if your lordship wants to go into the further facts, I can place that, Millet. The issue is this, so far as these medicines are concerned, there has to have some document substantiating that they own this medicine that has to be seized during the investigation. That documentation, nothing has been there, Millet. And Millet, Lordship would kindly appreciate that the tenancy, in respect of which he is claiming tenancy, he doesn't have any document so far as the tenancy of that premises is concerned. I am the sole and absolute owner of that premises. My husband has a partnership relation with this complainant in respect of one medicine agency. My husband have other different business also. Since my husband was not in a position to look after the partnership business, he was trying to grab the everything. On the basis of this criminal case has been foisted. Since I did not succumb to that, I am trying to protect my property, this criminal case.
Yes. Learned advocate for the petitioner is present. Third learned advocate for the petitioner peruse the materials on record. This application is directed with regard to quashing of ACGR case number 2114 of 2024 arising out of Thakurpukur PS case number 110 of 2024 pending before the learned Judicial Magistrate Second Court at Alipur. Learned advocate for the petitioner submits that the de facto complainant, for the purpose of harassing the petitioners, has instituted the case as there is some business dispute between the husband of the petitioner number 1 or 2?
Husband of the petitioner number 1.
Petitioner number 1 and the de facto complainant. Learned advocate draws attention to the order passed by the civil court restraining the de facto complainant, who is the defendant in the said suit, by an order of injunction. It is further submitted that although the petitioners are implicated and charge sheeted with regard to offense under section 380, but there is no recovery from the said petitioners and there is no materials to implicate them. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that this application should be admitted. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings of ACGR case number 2114 of 2024 arising out of Thakurpukur PS case number 110 of 2024 dated 18/4/2024, now pending before learned Judicial Magistrate Second Court at Alipur for a period of 4 weeks after vacation.
Extremely grateful, Millet.
Number 5, 6, 7.
6, 7, I'm appearing on behalf of the petitioner, Your Lordship. My senior is engaged in court.
Not today.
Grateful, Your Lordship.
8.
My lord, in 8, I am for the petitioner, my lord. At this matter, my lord, I am praying for expeditious trial, my lord. Proceedings, my lord.
Let me see.
My lord, on the basis of a suo motu FIR, which was lodged before the Bahrampur police station, my lord, on my lord 2017, February 2017, my lord. Under section, my lord, 294A, 420/34 of the Indian Penal Code, as well as, my lord, 3 and 4 of WBG and PC Act, my lord, and 7 and 9 of the.
Which year? Which year?
From 17, my lord.
You are the accused in this
I'm
case.
the accused, my lord. I'm the accused number. I'm the accused number 4. In last occasion, my lord, on 3rd of 3rd May 2025, my lord. The matter was came up for the hearing, my lord, before the learned magistrate, 3rd Court,
3rd May.
Murshid. 3rd May of this year, my lord, 2025. The report, the matter is, my lord, one of the accused, namely Danish Khan, he was died in the year of 2017, my lord. Since after his death, my lord, the death report has not been come before the learned magistrate, my lord. That is the reason, my lord, the
Trial is going on.
No trial is going, no charge was framed, my lord, till date, my lord.
Although charge sheet is submitted,
Charge is
is not
submitted,
framed.
my lord. Charge is submitted on 2017 itself, my lord. Charge sheet submitted, my lord, on 30th July 2017.
The charge is not framed.
No, my lord. The next date is of, my lord, 16th of December 2025 for appearance and report of the deceased person who has been died in 2017, my lord.
Yes,
Since
record and order. Learned advocate for the petitioner is present. Our learned advocate for the petitioner. This application is filed with a prayer for expeditious completion of proceedings being year case number 663 of 2017, corresponding to Barhampur PS case number 191 of 2017, dated 17/2/2017, now pending before the learned Judicial Magistrate, 3rd Court, Baharampur. It is the contention of the petitioner that although this case was instituted in 2017 and the charge sheet submitted on the self-same year, the case was transferred to the Court of Learned Judicial Magistrate, 3rd Court, Baharampur, Murshidabad on 22/3/2018. But till today, the case could not be taken up for consideration of charge. Learned advocate for the petitioner submits that one of the co-accused person died in the year 2017, but pending death report, the matter could not be taken up. In the facts and circumstances, this court is of the view that no fruitful purpose will be served by keeping this matter pending. Thus, this matter is disposed with a request upon the learned Judicial Magistrate, 3rd Court, Baharampur, Murshidabad, to expedite the case and take a decision with regard to the death report and decision with regard to the consideration of the charge within a period of 2 months from the next date fixed.
Marshal.
9. 10.
Yes, my lord, I'm for the petition, item number 10. Herein, my lord, we have assailed an order passed by the learned ACJM at Kontai, whereby our second prayer under 173 subsection 8 for further investigation was turned down. Now, my lord, may I very briefly
Where is that order? Let me see.
Yes, my lord. That is the certified copy is there, my lord.
Yes.
Order dated 13th of May 2025.
So this is the rejection order.
Yes.
So your petition was for further investigation.
Yes.
Which was turned down.
Yes.
And one of the accused person was discharged.
Yes. That is, my lord, my preliminary objection.
Anyway, serve notice and come.
Very well, my lord. My lord, will also kindly get the state to produce the case diary because
Yes,
I will.
learned advocate for the petitioner is present. This application is directed against order dated 13/5/2025, passed in GR 1356 of 2021 by the learned Additional Chief Judicial Magistrate Kontai. Upon hearing the learned advocate and upon perusing the petition, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation.
My lord, may kindly direct the state to produce the case diary, my lord.
The case diary be produced on the next date fixed.
Very well. I'm deeply obliged, my lord.
11, 12.
I'm for the petitioner, my lord. This is the application for expeditious disposal, my lord. Kindly see last 2 pages of my application. The certified copy of order sheet, my lord.
You are the accused.
Petitioner.
No, petitioner accused.
No, my lord. I am the petitioner. 125 CRPC. The application for maintenance is filed by the petitioner. My lord, 16/2/2024. This application is filed. Subsequently, on 19/2/2024, this matter was transferred to the Judicial Magistrate Court. So then 1, 2, 3 dates, 4 dates has already been passed, but
Any application for interim maintenance is pending?
it is pending.
Where is that?
My last page, my lord, kindly see order dated 26/3/2025.
26/3/2025.
26/3/2025. Both parties filed Hajira. OP also files a
Just a minute.
petition praying for time. And it is considered prayer is allowed fixed 15/10/2025 for interim hearing. My lord,
No, I have before me that is 16/2/2024. Okay.
Then
27/2024, 28/10/2024, 26/3/2025.
yes, my lord. 26/3/2025.
(15/10) is the date fixed.
Yes, my lord. My prayer is, my lord, kindly give a direction to the learned court below to hear this application without granting unnecessary adjournment to the opposite party, my lord.
Yes, record an order. This application is moved with a prayer for a direction upon the learned Judicial Magistrate, First Court, Barashat, District North 24 Parganas, for expeditious disposal of M case number 97 of 2024. Stop. It is the contention of the petitioner that the case is pending for more than 1 year. Until today, the application for interim maintenance is not taken up. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that no fruitful purpose would be served upon directing service of notice upon the opposite parties. Thus, this application is disposed with a request upon learned Judicial Magistrate, First Court, Barashat, District North 24 Parganas, to dispose M case number 97 of 2024 expeditiously and preferably within a period of 2 months from the next date fixed, without granting any unnecessary adjournments. Okay. Matter stands disposed.
Number 13.
13, my lord, I'm praying for not today.
Not today.
And number 14.
Lordship, item number 14, I'm praying for not today, your lordship.
Not
And
today.
15. 16. 17.
7. Yes.
I'm paying for not to 69.
16. Okay, not today. 17.
17.
My lord, 17. My lord, the petitioner filed a case under PWDV Act, Protection of Women Against Domestic Violence Act. She was destituted and deserted by her husband along with 2 minor daughters. The matter was filed and appeared before learned Metropolitan Magistrate 20th at Bankshal Court. My lord, upon contested hearing, learned 20th Metropolitan Magistrate, now JM, by her impugned order dated 9/8/24, page 22, my lord, 22, 23 and 24, allowed only 5,000 rupees per month each for the petitioner and 5,000 each for 2 daughters.
Okay,
Totaling-
as per the impugned order,
that is page 20,
respondent number 1 was directed to pay 15,000 per month. Okay.
my lord.
The order of the learned appeal court is this.
Now, my lord, allow me that my particular grievance is that before passing this impugned order by the learned 20th MM, my lord, kindly come to page 16, annexure P1.
Yes.
I filed a petition stating that my husband,
Page 60.
16.
Yes, 16.
16, my lord will file 2 pages petitions.
Yes.
My lord, there I mentioned that according to the judgment and dictum of Rajanish versus Neha judgment,
No, that the magistrate has passed the final order.
magistrate passed the interim monetary relief.
Oh, this is an interim order.
That was an interim order.
So against that, you have preferred an appeal before the session.
But the appeal challenging the validity and legality regarding not considering
Are you receiving the maintenance at now?
No, my lord.
No. In terms of this order, have you received any maintenance?
No. My lord, my grievance is that before passing the order, this petition kept pending without disposal of the petition, without going through the petition.
This is with regard to interim relief or final interim relief.
Interim relief, my lord.
Yes. Where is the order passed by the magistrate?
Magistrate order, my lord, is page 24 is the last page, 24, 23.
Yes. 15,000 per month.
From the date of filing.
Yes.
My lord, the order was passed on 9th of August.
For herself and for her 2 children. That means total is, that means 5,000 each.
5,000 is total 15,000. Now, my lord, the order was...
Anyway, you serve notice and come. Learned advocate for the petitioner is present. This application is directed against order dated, against judgment dated 6th day of May 2025, passed by Learned Additional District and Sessions Judge, Bench 2, City Sessions Court, Bichar Bhavan, Calcutta, in Criminal Appeal number 145 of 2024. The Learned Appeal Court, by the said order, has upheld the judgment passed by the learned.
My lord, that was not judgment, my lord. That was a
Passed by the order passed by
20th
the learned judicial magistrate, 20th Court, Calcutta, in connection with MISNS case number 15 of 2023. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that as there is no scope for any interim order, this matter should be heard upon notice to the opposite parties. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Yes.
Take item 31.
Yes. Just a minute. এটা কি আছে? Initial. এটা হলেই হয়ে যাচ্ছে তো? হ্যাঁ, ও এটা। কোনটা? ও অন্য একটা ম্যাটারে। ঠিক আছে। Yes, what is your matter number?
Item 20.
Item 20.
Mine is 31.
Yes, item 20 is for?
I am for the petitioner. It's a matter of expeditious disposal.
Okay, acha, item 20, let it appear as to be mentioned tomorrow. Yes, your case is?
31.
31, yes, what is the urgency?
My lord, I've been threatened, my lord, every day.
No, regarding what? You are challenging which order?
I am bound for washing of a case.
No, washing?
Washing of a case, my lord, I have come up for.
No, charge sheet is submitted.
Yes.
So when is?
I'll tell you, lordship, in one line.
Yes.
My sister was married to the opposite party number 2. There was a matrimonial discord. She was driven out from the house of.
Yes.
And continuously, he.
No, you are seeking quashing of a case.
Yes, ma'am.
So where is the scope of being threatened? The matter is to appear before the.
He is threatening me. That is why.
So that's a different issue. We can file a separate case against that. No, this has nothing to do with the threatening. You are challenging this case. That means there are some irregularities, or you are aggrieved by the investigation, or regarding the materials. So that can be taken up in the usual courts. If we do not reach, if there is some urgency, just wait for this week.
Can it be kept within the first 10 minutes?
No, let it remain. Okay. When is the next date fixed before the trial court?
Just after the puja.
Okay. Just wait for a few days. If we do not reach, I'll fix the matter. Okay.
My lord, item number 18, my lord, kindly makes it, my lord, not today, my lord.
Okay.
That's good, but you know, I'm great.
Honorable